Can I just say something about Andrea?
Welcome back, everybody. Ah, what a lot to go through today. Very big day. Very big day. Probably the most substantive day of the trial. Because today is where all of the pieces came together. All of the video that we can't see as well as anybody would like. And little bits and pieces around, rifle recovered, cause of death. All these things, they came together and connected the circle. Created the connections that prosecutor needs to prove in order to meet their probable cause standard and certainly to get to a jury beyond a reasonable doubt. But I think it's pretty clear at the end of the day that they have accomplished that. That said, there might be some wiggle room around the edges. Might be some wiggle room around the edges. I think we're going to have a short day tomorrow. Tonight, just to give you kind of a heads up, we got a lot to get through. I don't have a whole lot planned, like we've spent time going through case law and things like that in some of the other streams. I don't really have big plans to do that because I'm going to be tempted to, rant about tool marks, which I'm also going to try to keep relatively minimal. Other than to really make fun of Melissa Oberg from Delphi as appropriate. She's highly appropriate, really never not appropriate. So we don't have like a whole lot of stuff to look at, but we're gonna have a short day tomorrow, or at least that's what we're expecting. One witness left for the defense. Say it's not going to take very long, so I anticipate being finished by lunch. And then since we're not arguing, they want to have written briefing first, and we'll be coming back in almost a month. Or 2 months, almost 2 months. September the 1st to do the argument on bind over. We'll have a little more extra time tomorrow. So I think what it might be a fun thing to do is at that point sit down with the information. Let's look at the specific charges, and we can kind of recap where we got to this week and see where there might be loose ends, where there might be some thinner points than others, and get a little bit more of a perspective on kind of where things landed for the state. But we are definitely over the hump today at day 4. Got a late start. Not really surprising. Judge had called for a briefing. Kind of figured it might take a little extra minute. And we knew we were going to start off revisiting what do we get to see vis-a-vis Lance Twiggs? Do we get to see anything at all? Do we only get to hear? Is it going to be, how many chunks are we not going to be able to see? And so that is in fact where we started. Judge advised us, apologized, of course, for his lateness, but yes, he's taken a lot of time to think about the comments that have been made, the briefs filed. And yes, time is precious, but he needs to be prepared. Indeed, he does. And I appreciate very much him doing that. So he took time to review the filings, which I have not checked. Haven't checked the exchange again since I checked at lunch. But I will when we wrap here. And if today's filings have hit the docket, I will work on getting those up. But so we started first with the motion that was filed by Erica Kirk, victim representative. First thing he wanted to address, we looked at that at the beginning of the live stream. She wants everything shown in the courtroom. Everything shown in the courtroom. She has a right under the Utah Constitution to be present and attend. And the argument is that is not meaningful if all that means is she has a right to a butt in a seat and not to actually learn, not to see what the case is about and based on. So he first asked the state to address, do you want the benefit of the record on Ms. Kirk's motion? And so Mr. Ballard for the state says that her position fully accords with the state's, and that they think that publishing the exhibits in the courtroom is appropriate. On behalf of the defense, Mr. Novak said that the court's orders to date, he believes, comply with and respect the victim's right. And the issues presently before the court don't interfere with any enumerated rights of the victim representative. He says he also wants to be mindful of timing because we did argue a lot yesterday without briefing. Oh, the irony. The irony. Mr. Slovak. now wanting to be mindful of our time. The judge invited the media to participate because this is an issue involving transparency and publication. The media recognize we have this 3-step process: admission, publication, and cameras. These are all kind of separate analyses for the court to do. Media believes we should be able to see as much as possible, taking a maximalist position, except if you only publish it to the courtroom, they'd be satisfied with that for transparency's sake. That's not maximalist. That's not maximalist. Let's fuck y'all at home. Y'all who didn't come because you knew there was going to be a live stream. Never appreciate that from the media. Your point is to take the hard line. These other folks can offer the middle ground. Your job is to take the hard line. But this is where interests of the media and the interests of the public are not always in alignment. The public's interest is in access to the information, and the media's interest is in control of it. And you only get control of it when you limit access to it. So, very fine line sometimes between, is the media really our representative there in the courtroom? I mean, we'll take it. It's all we can get. But let's not be blind to the ways in which the media would be happy to throw we the public under the bus. Mr. Grunander just stated they wanted to be heard on the briefing, but the judge said, no, we're going to deal with the victim's motion first. So he says he recognizes Article 1, Section 28 of the Utah Constitution, recognizes important rights afforded to victims in Utah, acknowledge concerns relating to transparency, and he shares interests in transparency. At the same time, he has an independent obligation to honor and protect the defendant's constitutional rights. And he says the court determines that not all exhibits will be visually displayed to the courtroom. So he's going to use the 3-tiered analysis. And he's not intending to diminish the victim's rights and concerns, but merely to protect fair trial rights. And he states that the manner in which evidence is displayed remains in the discretion of the court. It must be appropriate, and the transparency must be consistent with the rights of all the parties. He denied access. We're not going to televise. We're not going to show in the courtroom, for example, the videos of the shooting. His statement on the record was grounded in the dignity of the victim. But there is another aspect to it that's a legitimate consideration, and that's the inflammatory nature of the video. They're the kinds of things that people react to. We saw the judge poker face graph Okay? I am never going up against Judge Graff when there's, you know, a flush draw on the board. Not going to do it. Not going to be able to read him. But he even, you know, he couldn't control his reaction. These are things that, you know, yeah, people have very strong feelings about, and rightfully and stuff. And so it's challenging not to let that emotion overcome well, just, you know, the thinking about the case, but just your reaction to it, your perspective to it and stuff like that. There's just no way that anybody's going to watch this high profile video and not be affected by it unless you're a psychopath. Just drop that in there. Judge, a lot of us noticed it. He seemed like he was carrying a very heavy burden this morning. Tired, sad, just seemed like he was carrying a big weight. And I think this was hard for him. I do. I think he does have a lot of empathy for Erica and Charlie's parents and what they are going through and what this process is like for them. It's not kind. It's not kind in the best of circumstances, and they are certainly not getting the best of circumstances. And so, you know, my read on it is I think he felt sad that this was what he felt he needed to do. Because I think he would have really liked to have been able to give her what he wants, what she wanted, but just felt that he couldn't. Just my read. But he said each exhibit, we're going to weigh it individually. And as far as the publication of the exhibit 16, you know, this is the 1102 that Lance, we've been talking about. If we want to be heard now on that. And so Mr. Ballard spoke first, but before he did, the court now has more edits, more to cut out. I'm like, you got to be kidding me. You got to be kidding me. We already cut out 16 and a half minutes out of a 30 some minute exhibit. We got more. Fortunately, it was not a lot more. Couple of seconds. So they had some kind of conversation about, you know, the editing process the state had already done. There had been some back and forth with the defense. They got it sorted out. So they had already prepared the exhibit based on what the court had said last night, was inclined to do. So then some additional sections that he wanted to take out. 7 seconds in around the 27-minute time, and another 7 seconds shortly after the 28-minute time. So it's only another 14 seconds, but I resent every little thing we don't get to see. I'm the maximalist over here. I get why we don't. Sometimes it's the job of the judge to tell me no. But I'm like, oh, more edits, but fortunately just another 14 seconds. So the judge also said that any video showing anything other than Mr. McBride and Mr. Twiggs, except for images pulled from the surveillance video, from the UVU surveillance video that we've already seen in the FBI bulletin, which we had not seen yet at this point, I don't think. but is it's public. It was the point. It was a news release. Was going to be disallowed, and that was part of the gist of the redactions. But so this gave us a little bit of an upside, which I wasn't expecting, because when we left yesterday, we're only going to hear the audio. We're not going to get to see any of this. But he changed course on that, and we did. We ended up getting to watch it. Still redacted, things we didn't get to see. But what we were allowed access to, we got to see it and hear it. So I did appreciate that. I think it's important to see demeanor, presentation. How does somebody come off? I'm not big on like, oh, you can tell, if somebody's lying because of, the XYZ, eyes shift to the left. I mean, a lot of that's bullshit. But there's no question that we are, as humans, nonverbal communicators. We express things all kinds of different ways. And so the opportunity to just assess that, I think, is very helpful. Myself, didn't get a lot of red flags visually from Lance. You guys may disagree. We revisited Mr. Ballard pointing out to the judge that the basis for the redactions yesterday was based on the cumulative nature, anticipating the future exhibits. And I was like, yeah, and how's it going to be duplicative if we don't get to see those? And as well as issues relating to the defendant's admissions. And so he says there are portions the court has ordered redacted that don't implicate those and should be taken out. So there was a section here. Couldn't quite tell how long there were, but there were two sections that he argued. These don't pose any kind of problem, so we should be able to hear that. So state arguing for more seconds back to us. I will take as many as I can get. I definitely appreciate that. Mr. Novak, I feel like they are, I'm sure they're aware. We know they're aware of, media commentary and stuff like that. It's their job. They're filing, big motions and stuff like that about it. But it feels like he maybe is starting to become sensitive to this perspective that it's the defense that's trying to hide everything. And using our logical minds, we can hypothesize why that might be. Why would you not want us to see the evidence? So he starts off by pointing out the first redaction. Judge, we didn't ask for that one. That was you. That was you, Judge. We didn't ask for that. That was your independent thing. That's the second one we did. The second one we did because it's not relevant, not admissible under 403. Doesn't affect the facts of consequences in the case. His concern, of course, the judge can not consider irrelevant information. He's the judge. But the broadcasting the irrelevant information, according to him, is the concern. And also he says he doesn't represent Lance, of course, but if I might anticipate what counsel might say, I might want to I think it would be consistent. I think they'd be on my side. Mr. Ballard points out, well, he did have a lawyer there and nobody objected to any of this. They knew it was for court. She had the opportunity to say if there was a problem. They argue it's critically relevant. Mr. Ballard says it's critically relevant because it goes to foundational information, identifying information relating to Mr. Twiggs, and very relevant, he says, to the enhancement they have charged. I must assume this is the victim targeting enhancement. So we kind of already have a gist of, the gist of this, of what's going on with all this. That, Charlie had what they call orthodox Christian views, which weirds me out every time I hear it. I know what he means. I just think he means mainstream. He has views that are not unconventional in the Christian world and relating to gender and sexuality. Lance and Tyler are not on the same side of that. And so that was the political expression relating to that particular topic was the reason why the state alleges that Tyler targeted Charlie. So the judge agrees, first off, with Mr. Ballard's unedits. The unedits. And so then we got a minute back. We got like a whole minute back. We did end up getting some timestamps for that. We got like a little bit over a minute on the first page, and says all of this can be played and published through the media. And then a second section that was like 13 seconds. They kind of quibbled about this back and forth, exactly how long. First part of it, judge is like, well, I'm sticking with my original ruling, considering it, but for publication purposes, we're not going to get to see what it is. But then an additional part, which was about another half a minute. What he says, I take it back. It's the other way around. The very first part of a section that's unclear, we will get to watch that. But the second part, about 30 seconds, he says there's interest, very vague. He's very vague. Interest served by not publishing, broadcasting, not based on what Mr. Twiggs might or might not assert, but independently. The court finds this portion of the statements doesn't serve the interests of justice to publish them. It's kind of what he is ultimately able to get out, which is a nice conclusion, but not a not a reason, because we don't understand why. Why doesn't it serve the interests of justice? And I understand there's some, this whole issue of giving away the game. If you're going to hide it from us, you can't really tell us what it is, but you could at least characterize a little bit what's going on. Could have been a little less vague, but it wasn't. So then that was his ruling on the Exhibit 16. So then we turned to the briefing. So Mr. Ballard starts. He says he has a few points. And so last night, he says the defense raised the issue of publicizing admissions or confessions by the defendant. He cited to the one sentence in Estes that relies on Rideau. Oh, guys, he's like, we paralleled last night, okay? We on the stream were doing exactly what the Utah County Attorney's Office was doing, and coming to remarkably similar, if not identical, conclusions. It relies on this one sentence in Estes that's based on Rideau that isn't really of good precedential value. It's from the dissenting opinion in Rideau. Rideau is a change of venue case. Like all of this, where does this come from? It's weird Estes would rely on that. It is. It was, it was motivated reasoning, I think is what it was, They were really mad about those cameras. They really didn't want them in. And they didn't have a strong legal justification for it. They don't have like a lot of jurisprudence about why this would be a problem. So they had to kind of build some, crib this the situation from Rideau and then cram it into just cameras in the courtroom in general and make it all a big per se problem, because they're really mad about the cameras in the courtroom. It just really pisses them off to be made so common like that. He points out Estes itself is about televising a trial, and then the Supreme Court has subsequently limited Estes to its facts. Exactly what we talked about last night. And so even if the one sentence from Rideau has some, precedential authority, it's not the same factual circumstance. Exactly what we talked about too. That was about change of venue. It was about biased jury. It wasn't about just per se cameras in the courtroom or not. So he described Rideau. He focused on as well the law enforcement involvement in the whole process. The fact that they elicited the statements, they arranged for it to be interviewed, they did it in this leading fashion, and then immediately went out and leaked it to the press, and it got published. And so it's not similar in terms of the types of statements, because this wasn't a police interrogation. This was Tyler voluntarily speaking to Lance. The police aren't involved at all. I'm not sure that's the critical part, but he's trying to make a distinction. He points as well, hey, if the Estes court is going to point to dissent in Rideau, then he'll point to a dissent in Rideau too, and points out, the dissent said, it's an impossible standard to have a sterile courtroom free from any external factors. And while I don't agree that justifies and excuses what happened in Rideau, which I think is on its face rather horrifying, it's hard not to agree with that. And again, there's a lot of law. You're entitled to a fair trial, but not a perfect one. There's always going to be some things, some mistakes. We are humans. Stuff happens. But you can't expect perfection. That would be a fool's errand. That would just essentially handcuff ourselves, and we wouldn't be able to have a meaningful justice system at all. He points out that other courts have followed the same line of reasoning. They criticize Rideau. They disagree that there's a blanket ban on publishing a defendant's admissions. He found this case from the Sixth Circuit that I'm gonna definitely check out when I get his brief, that involved what he said were, very similar factual circumstances, where it was during the preliminary hearing. It was the publication of the defendant's statements. They were ultimately held inadmissible, which it's not clear these will be, but they might try to make that argument. And the court in that case said it's not a per se violation of the defendant's rights, because we'll deal with it in jury selection. You'll see who heard it, if anybody heard it, screen those people out, call in more if you need to. Number of cases from the states as well that reached, he says, essentially the same outcome. He concludes by urging transparency is critical in this case. It also implicates the state's right to a fair trial. I cringe a little bit inside when I hear that. I know I'm not the only one, because, the Bill of Rights, the 14th Amendment, all of that, these are individual. These are our protections against the state. It's not the state's protection against us. That's why, like in Kentucky and the Mickey Stein stuff we're watching, they wrote it in. They wrote it into their venue statute, that the state can ask to change venue if the state doesn't think, their right to a fair trial is going to be impaired. I don't know if Utah has anything like that. I haven't looked. But, you know, that may be poor language. I think everybody agrees trials should be fair. They should really be fair to everybody. If I'm going to pick, you know, we have to err on one side or the other, I'm going to choose to err on the side of the defense just because I'm going to choose to err on the side of, you know, the underdog, really. The person who is kind of in a less powerful position to be able to kind of bully their way to what they want. But we all want fair trials. We all want fair trials. And he says that a vacuum in the evidence fuels speculation, and he's right. A vacuum will be filled by something. He agrees it's also critical to the victim's right to attend the hearing because that's a hollow promise if all it means is just a right to be physically present, but in a seat. Then we heard from Mr. Novak. He thinks this is really on point. Strong parallels with Rideau, the confession that was televised by an act of the state. The issue is that the issue is not whether or not it took place in a courtroom, according to Mr. Novak. The problem is that the state is who caused it to be published, which is kind of exactly what Rideau didn't say. Remember, they were like, that part's irrelevant. How it got out there is irrelevant. I'm like, oh, really? We're gonna look at due process and consider everything except the police trying to stack the deck? Not relevant? Yeah. Kind of the opposite of what Mr. Novak was saying. But he says in this case, the courts granted the electronic media coverage request, and that's a state action, and the state has supported it, and that's a state action. And of course, if there weren't cameras in here, Judge, we wouldn't have this problem. Want to make this problem go away, Judge? It'd be real easy. Be real easy. There's that little implicit. It's not really a threat, but I don't know. Maybe a low level one. It's going to continue to be difficult as long as you let the cameras in here. That may just be reality, you know, but he points that he argues that Erica Kirk's request is just for people in the courtroom to see the evidence, but the state is trying to go even further than that we at home should be able to see it. I'm like, yeah, because there's no real good reason to distinguish between the people in the courtroom and the people at home. We're not second-class citizens over here, notwithstanding you treating us like it. The state wants to publish the confession the same way in Rideau did, not the same way in open court properly, not leaking it to the press to publish, you know, on nighttime TV. But he's argued state action. So he backpedals on, you know, yesterday, remembers per se due process violation to publish the confession. Well, now he's backpedaled. Now he's backpedaled, which is smart because that wasn't right. And I can't say he knew that, but these cases have come up before. Side-eyeing you, Mr. Novak, now. You made me. You made me. I was trying everything not to, but now I'm stuck. Now I'm stuck. I have to side-eye you. But he backpedals. Oh, yeah, the state's right about not per se, and they backed away and yada, yada. But then he points to a Skilling case from 2010 where the court said we're going to let judges decide whether juror exposure to pretrial publicity makes them unable to serve. Generally going to be up to the trial court, generally up to the qualifications of the jury that's presented. But at the same time, there are extreme cases where prejudice will be presumed. So yeah, I'm going to want to look at Skilling too. Not not real familiar with that one. The name is familiar. I know it's come across my radar, but I don't think I've seen it anytime soon. Anytime recently. So I'm going to take a look at that because I'm curious. Okay, there might be some extreme cases. Is this just your way to try to clean up the very messy line of cases that got you here? The Rideau to the Estes to the Chandler, and like Chandler, refusing to just flat out, we reverse Estes. We're going to honestly read what it said and say it's wrong. Instead, we're going to pretend it says something that it doesn't and then say it's limited to that case. Creates all this confusion about, what's still good law and what isn't. So I'm curious if this is just a way to clean up, try to tidy up that jurisprudence, or if they've got something in mind. Like, did we have examples? Do we have other citations? I don't know. I'll be interested to see that. And he says that's a fact-based determination, which is absolutely, I agree with that. He says the court has already made findings that this is an extreme case vis-a-vis the volume of publicity, the monitoring by the public, the speed of the proceeding, the proceedings being digested and broadcast. So he reiterates that the exhibits, the 16.1, the text message chain, 16.2, the Discord chat, and 16.3, the photograph of the note, needs to be managed the way we've said, which is basically get into evidence, but not public for anybody. So Mr. Ballard then says, Mr. Novak has misrepresented our position. We're not trying to go beyond what Erica Kirk said. We just want to publish in the courtroom too. I'm like, well, then what help are you? Then what good are you? Here we were about to give you some kudos for not treating us all out here like second-class citizens, when not a single person in this courtroom has offered a good reason for distinguishing between what you can see in the courtroom and what we can see at home. The only one has been, well, you might be able to screenshot it and copy it. If people can relate the contents of it anyway, who cares? Who cares? Who cares if I can listen to somebody say what it says and learn that way? Or read it and learn what it says? This is a public hearing. Those present in the courtroom should be able to see. Why not us at home? Why not? Media participation again. Thanks the court. Taking the time. Spent a little bit of time acknowledging the time it was taking. It's so meta lawyer. Apologizing for taking up time and taking up ridiculous amounts of time repeating yourself about how thankful you are for the time. So as to the publicity surrounding admissions or confessions, he says the court is looking at Rideau Estes, but you should look at Algier. We looked at this. Not last night, but one of the other nights. We've looked at Algier. This was the one where 2011 Utah Supreme Court case, unanimous decision. He says it has striking parallels to this one. It's a murder case where there was a letter from a jail inmate that went into the court file. It was describing or reporting a confession allegedly made by the defendant. So you go through the two-step analysis. Is there a presumptive right of access? Yes, there is. It's open court record, same standard applies. And then the balancing test after that. Balancing of the rights. Is there a compelling interest that needs to be protected by some narrowly tailored means? He says with respect to paragraph 17, which I think is Oh, what he was saying was that at issue in that particular case, one of the observations that they commented on, one of the reasons why they weren't particularly troubled by this being public, was that much of the information was already public. And so then if you conceal it, all it does is create the impression that something is being kept from the public, when in fact it isn't. It's an own goal. It's unnecessary. You didn't need to do that. You created suspicion out of the idea that, it would be prejudicial if we've seen it, but we've already seen it. And so he says that's applicable here. The balancing test hasn't been overcome in part because much of this, the text messages anyway, are already public. He, again, recognizes they want both the courtroom and the cameras, but we recognize the courtroom alone is a meaningful step towards transparency. Thank you for those bus wheels going over my back very much, Mr. Media Lawyer, sir. Mr. Neiman, Kirk family representative, had his chance to speak. He simply says the Kirk family has waited 8 months for this hearing. They have the right to see, feel, hear the evidence. And at a minimum, the evidence needs to be displayed in the courtroom. Judge goes back to, the 3 factors we got to deal with for each exhibit. Let's work through what do you want each one. Go through with each one. So Mr. Ballard says we are asking for admission, publication within the courtroom, but not electronic transmission of the text messages, the Discord chats, and the photograph of the note. He says, now once admitted, we're going to have the witness read from portions, but not display them. Not display them in the courtroom. That's what Mr. Ballard wants to do. The judge wants to know how much of the text message chain has already been published to the public. Mr. Ballard, says, well, there's some on pages 8 to 9 of the information. We know that. And the judge is like, well, but what percentage of the total of that's on 16.1 is already public? So it took them a while for them to kind of go count and calculate. And what they figured is that the total text chain is 18 pages long. They have already published 5.5 pages equivalent in the information. The media points out that the note as well is described in the information, the contents of the note. The victim rep, again, just says this has not been easy for the family. They deserve to see the evidence and to know what happened to Charlie. I'm screaming, the search warrants, the search warrants. Those are public records too. And there were more of the texts in the search warrants, but nobody brought that up. Nobody brought it up. So going to the judge, says the main question here is publication of the exhibits in court and beyond. So vis-a-vis the briefing, we're dealing with 16.1, 16.2, 16.3. These are the texts, the Discord chat, and the handwritten note. He says the defendant argues it would create a substantial risk of prejudice, potential 14th Amendment due process violation, relying on Rideau, Estes, and Skilling. He's already read. He's like reading this, by the way. He's already written it. I couldn't see if he was like maybe doing any tweaks or anything while he heard the argument, but he'd already written this decision. So I did find that interesting and notable. The state responds that there's no categorical restriction, that these communications are materially different, and any prejudice can be managed. Also implicating the victim representative's right to be present. He says, on the present record, he is not persuaded that publication creates this presumed prejudice. They were made outside police custody. They were offered in the ordinary course of court proceedings. Any potential prejudice can be addressed through the trial process, jury selection. And pointing out this is not about admissibility at trial or at any other point. So he is overruling the defense's objection at this point and says the state may publish 16.1, 16.2, 16.3, all of them, except There was, I guess, a phone number in one of them that needed to be redacted. Except it's only going to get published in the courtroom. Text messages, those can be broadcast, he says. That exhibit, that can be broadcast. But the rest are going to be only in the courtroom. So we had the edited video ready. State, I'm sure, was working on that last night. Had a couple few additional tweaks, per the judge's instructions this morning. But otherwise, they're ready to go. So we take the morning break so that we can come back and get right into it. So then we got Lance's interview. Starts with the whole 11-2 admission from Mr. McBride. Kind of like we predicted. They're going to do some basic preliminaries. Then they're going to do this part, the formal part. We did. I was curious. Are we, going to get to hear all this? We did. But also, we got to see this on the monitors. We got to see it. He did not at the end of the day. And again, without explanation, like originally it was just audio. He backpedaled. Great. I'm glad. But I don't understand why. And I just wish I did, only because I think it would be helpful to, enable us to show him the wisdom of continuing to apply that logic in the future and perhaps more broadly. So they did. They started with that 1102 admonition. He's taken under oath. Also, the acknowledgement that he has been given state and federal immunity for things that he discusses. His name is Lance Twiggs. He knows Tyler Robinson. That's the guy that's charged with shooting Charlie Kirk. He's aware of that. They first met in 2023 in person. He says he has known them longer than that. It sounded like they met through gaming. As far as their relationship, says he didn't know him super well at first. He was just a new roommate in 2023. They had some friends in common, I think, from high school, and knew he liked to play games. And so then the relationship progressed, and about 2 to 3 months after Tyler moved in, they began dating. And so they were living in that apartment complex in St. George. It's the same place they were living on September the 10th. They had separate rooms. They did not occupy the same room. On September, in or around September of 2025, generally, he was working. He was doing bathtub and shower repair for construction sites and stuff. Tyler was working for an electrician, and he was also in trade school. He didn't really understand, much about that. Kind of understood that it was to train up as an electrician, but he says he's not really sure how the trade system works. What this sounds like to me is the union apprenticeship program. That's what it sounds like to me. That's when you go through the union, that's kind of what they do. Like you get a job, but then you also have to go to class, and they just work you through that way. So it might have been a union trade apprenticeship. Good money. Good money. Electricians make good money, man. Fortunate. It's unfortunate. The path this kid was on. Anyway, so normally Tyler for his workday would leave around 7 and then would be back 3 or 4 o'clock. It would just depend on the job. And then on certain days, he would have to go to school in the evening. So he would leave again at about 5 or 6 at night. We turn to September the 10th. The night before, September 9th to September 10th, he spent the night at their apartment. Lance says he doesn't know exactly when Tyler left, just that it was very early, saying he had a long drive to work that day. He says normally he would have thought, what time was it? Would have guessed normally around 5 o'clock, because that would be a normal early day for him. But says he thinks it was probably more like 4. So earlier than his normal early day. He himself, Lance, got up around 12 to 1 p.m. I'm jealous. I'm jealous of the ability of the youth to sleep in as they do, which actually makes me wonder if Tyler is leaving around 4 and you slept till 12 to 1, were you still awake this whole time? Were you like up late until Tyler left? They didn't ask, he didn't specify, but I am just kind of curious. There's no, I mean, I couldn't sleep to 12 anyway. Too old for that. But only way I'd even have a chance to do it is if I stayed up till 4, you know. Get my 8 hours, wake up at noon. It's like the only way it's even conceivable. I do wonder. So Lance wasn't working that day. Tyler, he says, sent a message to the group chat, but otherwise did not message him that day until he got the automated message at 11 p.m. They stopped and turned to engraving bullets, and Lance says yes, he does remember. Tyler engraving bullets, doesn't remember exactly when this happened. But Tyler had said he was going hunting with his family, and he had asked if they had a Dremel. And so Lance told him where the Dremel tool was and just asked him, please don't blow up the bullet in the house. That would be good. That would be preferable, certainly, to avoid blowing up the bullet in the house with your Dremel tool. I was thinking about this because I know there's many swirling questions and everything about Lance and his credibility, and is he minimizing his own involvement, and all of that type of thing. Completely understandable. I get it. But it did strike me that this particular part of his testimony, he didn't have to admit this. He didn't have to, you know, if he's trying to be deceptive or, you know, try to help cover up for Tyler or anything. He didn't have to admit this. May or may not mean anything. Because they have no other way to prove it. You know, how are you gonna prove that he knew? At best, you have a he said, she said between Tyler, if Tyler testifies and they point the finger at each other. But I don't know. I just was kind of thinking about that. If he really was trying to minimize, trying to cover up, he didn't have to admit that he knew this, but he did. Maybe slight evidence to me of Lance's sincerity. Cuts in that favor anyway, as I see it. You might disagree. Tyler had been talking about this hunting and camping trip for months. So as far as when exactly this conversation about the engraving and stuff happened, it was not as much as a year ago. It was, he says, at most a month before the shooting that he was asking about this. So then the note that he left. So we turn to the texts that he was looking at, and then the notes. They had been looking at the text. Okay, I take that back, because of course we didn't get to see the texts cumulative. So they had been talking about that, but now we are turning to the note 16.3, and he recognizes it. This was the note that was under Tyler's keyboard that he was referring to in the first text in the exchange. And so Lance found it on Tyler's desk under the keyboard. So he read it and put it back down on the desk after he took a picture of it. And that was around 11 p.m. on September the 10th. He took the picture of it, and because of that inadvertent glimpse we got from the camera, we saw the note was intact at this time. It was unburnt. Once again, if Lance is trying to minimize, keep involvement, you know, limited and stuff like that, he didn't have to take this picture. I don't know. He says after that he didn't see it again. So when he last saw it, according to Lance's testimony, it was intact. Next time it's found, it's burnt in the trash can. Clearly that would indicate, if Lance is if Lance is telling the truth, that it was Tyler that burned the note. That's going to be consciousness of guilt at trial. Reiterates that Tyler is in a separate bedroom. They don't share a bedroom. So finding, his keyboard, the note under the keyboard, he would have to go into another room that is not his. Then we go to the Discord messages, and he says, yes, that's the server friend he was mentioning, and they're looking at these messages from his phone, photographs from his phone. Identifies it as his. It is a Discord server. The members are Tyler's friend group. They were a group that played Dungeons and Dragons together every week. They talked about some of the abbreviations. DM is the dungeon master, for example, just clarifying some of the things that appear in these chats. There's also names that they were using in the game, I think, that the people were associated with. Maybe it's showing in the messages. So he says he thinks this Discord conversation, this was on the 11th, because he doesn't think that as far as SMS, that Tyler messaged anybody else before he messaged Lance. I think he means, about quote unquote what happened. So the messages that he got, Lance, went from September the 10th over into September the 11th. On September the 11th, then he saw Tyler, and that was the day after the shooting. So Tyler was up. He was doing stuff around the house. He saw him after the message. He's describing a message where Lance said, I'd have to come home. I'd come home to do laundry because I don't want him to, I didn't want him to come to my parents' house under these circumstances. We've seen these text messages that I remember. These were in some of the search warrants because Tyler's saying he's going to, turn himself in and so make an excuse so you can come home. And Lance is like, what should it be? And he ends up coming up with the laundry. I'll tell him I have to do laundry. So we have seen that before in the search warrants, if you have seen those. So that's what that's talking about. And he didn't want him to come to the parents' house, under the circumstances. So saw him, says he said bye, he drove off, and Lance went back to his parents' house. Didn't say how long this was, but he said that Tyler was walking around a lot in the house. He didn't go into a lot of detail about what happened. Lance just asked him if what he said before was true. He says Tyler said that it was, and he began crying and said he wished he hadn't done it. The regret. I'm glad he expressed it, at least according to Lance. It's good that he's capable of that. Made a terrible, terrible mistake that he can never undo. May never be forgiven. May never be able to make up for it. But that recognition to me, I've said so many times, I'm a big fan of redemption. I'm a big fan of redemption. You have to be, or why are we doing any of this? We have to believe in people's ability to be better than the worst thing that they've ever done, to maybe not ever be able to make up for their mistakes, but to make every effort to try the best they can to get there. And this is the spark of hope for that, for me. To me, this is somebody capable of redemption, if this is true. At least at this moment, he was capable. Could change. Things could change, but that's what I hold out hope for. So that hit me. I'm sure it hit lots of people. Wished he hadn't done it. Does that sound like a confession? This is what this is the little argument about, oh well, is it a confession? Is it an admission? The state's going to call it that. Yeah, I can see why. I can see why, because certainly does imply he did it at the very least, doesn't it? Pretty strong implication there. Wished he hadn't. Tends to mean he did. So he seemed like he was walking around to kind of distract himself. You know, he's crying. Wish he hadn't done it. He's trying to distract himself from whatever. So eventually he said that he would, there was like a break and break in the testimony a little bit. You know, you can tell like we're not getting to see part of it. And then eventually he said he would talk to his parents and turn himself in. And Lance, didn't want to be at the apartment while any of that was happening. So that was part that we didn't get to hear, and seems like that relates, I would suspect, to the threats of self-harm, perhaps, that we have heard about. And again, in some of the probable cause, I don't remember if it's the charging document or the Davis affidavit, but they reported statements like that, I think to Mr. Mitchell as well. So that would be my guess, but don't know for sure. He had seen, let me see. Oh, he had seen, as far as like his awareness of kind of what had happened and everything. He said, yeah, I'd seen an Instagram link from the group chat, but hadn't looked at it, hadn't really been paying attention. And he said the next day, the 11th, he saw the images of the suspect. Says he doesn't think he saw that on the 10th. Pretty sure it wasn't released to the 11th, so that would make sense. So then he's shown the FBI press release, and he's shown all of the photos of the person. Asked if he recognizes this person to be Tyler. He says, "Well, I wouldn't say I'm 100% certain, but does look like him as far as the shoes, the sunglasses, the jeans. Maybe not that specific hat I don't recognize, but he did usually wear a hat." The bottom two, he says, the ones where we have a clearer view of the face as he's coming up the stairs, starting like at the bottom of the stairwell, starting to come up. Those two definitely do look like Tyler, he says. I think the bottom two might have been in the red shirt too. So it was earlier in the day. The earlier, Can't remember though. Funny how memory is, right? Those little details. But as I think about it, yeah, I think the red shirt. I think those were a red shirt. So it would have been the earlier in the day trips to the campus. That one definitely, he says, looks like Tyler. Those ones. So he says he did talk about all of this with Tyler's friends. I think he means the Discord chat, but not clear. Talked about it with his friends. Not sure he talked about any of it with his own. He didn't have his phone for a while, and then he's gone off social media, not using social media. Also understand that. He describes gaming. He used to game with Tyler. They would play some party games, anything multiplayer. Tyler particularly liked Sea of Thieves, where he would play a pirate, fight sharks, and things like that. Some what he called co-op games, cooperative games, where you have to work together to win. And he says, way back in high school, we played shooting games. So I think that's where I think they met. That's what he's saying. They met through gaming, but didn't know each other in person until 2023. He talked politics. Tyler did a lot more than Lance, according to him. He says he doesn't keep up much with politics. Tyler would talk about mostly what he had heard in the radio on the truck, in the truck on the way to work, because they would like ride to work together in the common truck. And he described that as, it's more Tyler than him. So didn't necessarily have a lot of conversation because he didn't really contribute to it. He says personally, he had never heard Tyler talk about Charlie Kirk before specifically. Never really heard Tyler talk about gender LGBTQ rights. Not really. He says usually politics were about Trump, about current policies or issues, things that were being voted on. They're going to have Tyler's entire chat history, right? They got his phone, got all his devices, every website, forum, server, everything he's ever been on to talk about stuff. They're going to have it all. So I'm going to be interested to see just the general pattern of what does Tyler talk about for politics. Maybe he doesn't put stuff online. I don't know. Some people only talk in person, don't like to do political stuff online, but some people like to do a lot of talking about politics online. I wonder what we'll see there. Then we go to we have this little break about to some people he goes by Luna. He says he went by Luna to some people, but not as an overall thing. And this is just kind of dropped in there in the middle of a big edit. We get this little bit. To some people he went by Luna, but not as an overall thing. Doesn't really sound like somebody who is actively, aggressively, publicly transitioning. Sounds like at best more of a little toe in the water thing. I don't know. A lot we didn't get to hear. Asked about a Dremel tool. He says Tyler had asked for the Dremel tool to inscribe the bullets. Lance, had a Dremel. They had a section in the apartment basement pantry where they kept the household tools, and so it was down there. He told Tyler where it was. Sounds like that's about all he knew about it. That was it. That was what we heard. That was the interview. They concluded, for our purposes, with the Dremel tool. So we go back then to Agent Davis, who is the sponsoring witness for this. Agent Davis of the SBI. He's back on the stand. Confirms he was physically present at the interview. It's fair and accurate. Acknowledges the items of evidence that were shown to him during the interview. Said it many times: text, Discord chat, the note, and also the FBI press release. So now he authenticates those exhibits. We start with 16.1, which is the text chain. So we establish first off, these are the photographs of Lance's phone. Clarify, because sometimes they misstate and say screenshot. I've seen that a couple times, I think. They are not screenshots. He clarifies these are photographs of Lance's phone. And they're taken because in the first interview he had with the FBI, which we know was on September the 12th, early morning hours. He showed the FBI these messages, he described them, and allowed them to photograph the phone. I've talked about that before. Why do they do that? Because they document it right now. That way, in case your phone blows up or oopsie exploded, or, somehow, bust up the SIM card and put it in a bag and drive it onto an Air Force base and put it in separate dumpsters. These things can happen to the best of us. So they preserve it because, you want it. You want something, some kind of backup in case for whatever reason you aren't able to extract this phone. He acknowledges that it is his phone. He refers to a large crack on the screen to identify it. And he had the phone with him at that September the 12th interview. So the same text thread then was shown to him at this interview that we watched, the April 20th one. The person he was chatting with is entered as Tyler in his phone. He identified Tyler's phone number as the contact, checks it against the official records, it matches. So seems to be legit in that respect. Thinks it's an accurate text thread. They have subsequently performed a Celebrite extraction on Lance's phone. We know they took it from him that morning. He volunteered it, so they extracted it pretty early on in the investigative process. We still don't know. Oh no, he volunteered. He volunteered it. He volunteered it. So they didn't need a warrant for his phone. This also, to me, is a pretty good indication of Lance's sincerity and indicative of non-involvement. Not a guarantee. Definitely not a guarantee. Because I can't tell you how many times police will be like standing at the trunk of the car with the driver and be like, so you going to give me permission to search the trunk? The person be like, sure. And you open the trunk and there's like 20 keys of coke in there and some guns, some sawed-offs. Like, it's there. Why on earth are you saying yes? People do really stupid things sometimes when it comes to authorizing searches. So, I don't know, maybe it's not a very good indicator that agreeing to the search means you think there's probably nothing in there, because obviously situations where people know perfectly well it's right there, they're going to see it, they will still consent to the search. But it's non-zero, I guess. It's just that reality doesn't always work that way. There are some serious dum-dums out there with a lot of freaking coke in their trunks. That's all I can say about that. But he allowed them to take the phone. They did the Celebrite extraction, and the Celebrite extraction confirmed that they had exchanged these texts between September the 10th and the 11th. And the first text in that chain took place, as he reported, September the 10th at 11 o'clock. So Exhibit 16.1 is admitted and allowed to be published. We finally get nothing, objections, nothing further beyond what we've already done. We're not re-arguing the standing objection and trying to come up with other stuff, just nothing further. Oh, thank you. Thank you, Mr. Novak. Brevity really does look good on you. Just for what it's worth, my 2 cents. So we get to see now the text. I didn't write everything down. It's going to be, again, lots of it's already public, and I am 100% sure it's screenshot, clipped, whatever. People are going to be able to scroll through and read everything. But it's the drop what you're doing. It starts and go look under my keyboard. What I hadn't seen was Lance responds, and then Tyler responds back, all caps, Fuck, I tried to delete that. I guess he tried to delete the auto text, but didn't. Don't know. We identify that Tyler is the gray message and Lance is the blue message because this is an iPhone. Also good to know because of just the implications, cloud backup, and all kinds of things with that. And he agrees. Lance also, acknowledges in the interview that the contact shows Tyler and that it's Tyler. And we go through the I'm still okay, my love. The texts. Sorry to involve you. Repeatedly, sorry to involve you. Are you the one who did it? I am. I'm sorry. That's a confession. That's a confession. I am the one who did it. Yeah, that's a confession. Talking about, not finding his rifle, asking why he left it behind originally and does it have a serial number, and Tyler doesn't know if it has a serial number. He says he's worried about prints. He had to leave it in the bush when he changed clothes because he didn't have the ability to take it at that time. I think it's just, it would be exposed. You don't have anywhere to put it. People are going to start rapidly getting into this area, and you can't be trying to walk into the parking garage to get your car with your long rifle. It's going to get some attention. He says the only thing he left was a rifle wrapped in a towel. That's not good also. That's quite incriminating. That's knowledge of the condition of this rifle that they found in the bush. That is a connection between Tyler Robinson and the gun right there. Just knowledge of what it was, where it was found, and what condition it was in. The gun was old as shit, and Gramps had done some modifying. So he wasn't sure about if the ownership was going to be able to be traced. He was like, maybe, hopefully it's just some old dead guy that sold it to Gramps a long time ago or something like that. Excuse me. Next thing I wrote down is about Tyler saying, I'm going to turn myself in. My neighbor's a sheriff. Can do that. So those are the things I wrote them down, like the stuff that just I didn't remember having heard before real specifically. So that was really it. There probably is more, but like I said, we got to see them in open court. They're going to be screenshot. They're going to be clipped and played everywhere. So it's all going to be available. The text Celebrate extraction established that the last text was sent just before 8:00 p.m. on September the 11th. The I'm going to turn myself in, kind of final text. And he then clarifies it's 7:42 is the date of that exchange. So then we move to Exhibit 16.2. This is, again, photos of Lance's phone, but now it's the Discord messages that he talked about and confirmed in that interview. Lance is part of the thread. He does not reply, but he says he was there. And Tyler was also part of the thread. Lance confirmed all of this in both interviews. Tyler's username was Tyler-Ikum, IKUM. I don't want to know any more about that username. That's all I need to know. Didn't even really need to know that. But now we know. Tyler-Ikum. They did send a subpoena to Discord. They did recover those messages from Discord. He reviewed the messages. So the first messages sent in this exchange was from Tyler at 7:57 p.m. It's referring to the thing from yesterday. So this was September the 11th, would have been referring to September the 10th. And then Tyler arrived at the Washington County Sheriff's Office about 9 o'clock. So, he reviewed that. He wasn't there, of course, but that was based on the police reports and also reviewing the video. So he confirms that that's correct. 16.2 is published, but only to the courtroom gallery. So we are dependent on the folks in the courtroom to report to us the content of those Discord messages. Then we have 16.3, the handwritten note from Tyler to Lance. The one that he told the FBI about finding it under the keyboard. So law enforcement got this image from Lance's phone. His phone was taken into evidence and downloaded. Again, that's what it means. A Celebrite extraction they did at the Regional Computer Forensics Lab. And then SBI receives a flash drive of that download. They send it to an information analyst to go through and look for evidence. And they located this image of the letter in that process. Celebrite's commonly used by law enforcement to download electronic devices. Probably the most common. The gray key is also common to get the extraction itself, but it doesn't parse. You have to have another tool to actually interpret it. Celebrite does both. And so that's why law enforcement agencies like it. It's a one-stop shop to be able to get into people's phones. He didn't talk, he says, to the specific analyst at the lab who did the extraction, but they did provide this to the FBI. And then he also spoke with the officers who recovered the photo, the ones who did the analyst, the analyst who did the review and located it after they got the extraction. So he didn't talk to the extractor, but he talked to the person who looked at the extraction to, confirm that that's what they found. Lance was shown it during the interview and talked about it. It's admitted it's published only in the courtroom for now. For now. There was an inadvertent little camera slip. Then 16.4 is the FBI release. Davis says he had seen this before on the website. I'm pretty sure it's still up there. If not still, it was, long after the case had started, it was still there. We then have this, so they agree we're going to admit and publish this in the courtroom, but then our sound goes mute. Our sound goes mute. They're having this long ass argument in the courtroom that we can't hear. What the hell is this? What the hell is this? This is not like a sidebar where they, they're having this conversation out of the view of the public. They're having this argument in open court, in front of people in open court, and they got us on mute. I've never seen this before. And I'm baffled by it. I'm baffled by it. I am baffled by being surprised by it, just out of nowhere. No conversation about, so do we need to turn off the mic? Why we need to do this? Just out of nowhere and no reasoning, of course. Didn't like that at all. Didn't like that at all. So I verbally committed myself to get the transcript. Guys, I'm gonna wait until after the state orders it. Remember, they said they can order it expedited and probably get it by Monday. I'm gonna wait till after they order it because typically it's cheaper after the first person orders it to get this. The second copy, the first person who has to prepare it pays the bulk of the cost, but then the subsequent people are just paying for copies, and it's usually less. It shouldn't be crazy expensive. But I want to see what this argument is. You didn't close the court. This transcript should be open, shouldn't be sealed. We'll see if there's any issue with that, but what the hell is with this? We go back to 5.1, which was previously admitted on day 2. Contingent on foundation, they say it's now been laid, and this is the 1102 statement of Mr. Englehart. There had been argument on this one about publication. Remember, they said it wasn't relevant anyway because it's about Charlie's Christian values, and that doesn't matter, but also more prejudicial than probative, et cetera, et cetera. So court had said we'd already found it's relevant, goes towards religion, yes, but it's relevant to the enhancement. So he said this can be publishable to everyone. So they published it on the Monitor. But the cameraman didn't do us any favors vis-a-vis, figuring out how to film the reflective lit up surface of the TV, and completely illegible trying to see this as well. Fully expect somebody is going to have screenshot this and played with enhancement and contrast and all that stuff, whatever, to try to make it legible. So I expect that will be out there, but we were not able to meaningfully see what it said in our court session today. There's a comment now then just referenced from the text messages where Tyler is saying, stay silent and talk to a lawyer. Brings that in. To the extent this is supposed to be support for like witness tampering, nowhere near enough. Not going to fly. Not going to fly. If telling somebody to stay silent, don't talk to the police, talk to a lawyer, is illegal, every defense lawyer on the planet is going to jail, and will continue to as a matter of principle. I will not stop giving this advice. This is perfectly legal advice. I don't see how you can elevate this to a crime. I recall from the text messages there's something in it about, destroy this or destroy the note or something like that. So that might be enough. But that's why they're bringing this in as proof of tampering or whatever. No. And I don't even like that they would try. I really don't. Very bad taste in my mouth that giving somebody extremely good general purpose advice to exercise rights that they have, not to talk to the police and to talk to a lawyer, is now a crime. No. Bridge too far for me, for sure. Remember when they did that in Karen Reed? They wanted to argue the adverse interest because Karen called a lawyer after Buchanan, set up the interview at her house. Gee, in hindsight, do you think that was a smart thing to do? Do you think it might have been better if the lawyer had been present with her that day? Yeah, put a real bad taste in my mouth that they wanted to do that. Talks about flying down. Reminder, he flew down to the Washington County Sheriff's Office on the 11th. He saw Tyler Robinson there, got his name, transported him, booked him, recognizes him here today. Doesn't do the point, but describes him verbally. He's in the center chair over there at the defense table in the gray suit with the green tie. No objection to the in-court identification for this hearing only. They'll have to do it again at trial and at any future hearing where identity is relevant. So that was all for Mr. Davis on direct. We're already anticipating lunch. But then we learn defense isn't going to cross him. No cross. No cross for Mr. David. No cross about the timeline. No cross about the Discord chats. No cross about the messages. None of it. No cross on anything. They're carefully crossing, bringing in for the purpose of crossing the forensic experts over rather detailed and technical nuances relating to their methodologies, but not crossing the police officer on some of this highly, highly incriminating evidence. I know what conclusion I draw from that, because there's no fraud relating to that evidence. No fraud. So we did have our lunch. We had our lunch. And then we came back to Jen Valmuina. And I just continued. I continued to really like her. She's great. She was assigned to go to Utah Valley University on September the 10th. She got there about 1:30 p.m. Before that, she had been at the division headquarters in the Salt Lake City and then went straight to campus, where arriving at the south end of the campus, she saw multiple police cars, all kinds of officers from different agencies. She went to the Fugal building where they had set up the command post. Officers at this time were securing the campus. What that means is they were canvassing the area, trying to look for the suspect, but also seeing if anybody else was injured, and also making sure no unauthorized people were coming in. So it's like a lockdown kind of situation. Her assignment was to oversee the crime scene and the physical evidence. In order to do that, to process the scene for evidence, it had to first be secure, meaning they have to verify there's no active shooter on campus, which means they have to clear all of the buildings on campus. They have to enter them, search them, make sure there's no shooter in it, and then secure it. So they went through all that before she can start processing the scene. We start by talking about the rooftop of the Losi Center. So the Utah, Idaho Bureau of Forensic Services, which is their crime lab, did the processing of the Losi Center rooftop. They documented it with sketches, with photos, evidence markers. They label and package the evidence. They ID anything probative. This is what crime scene processing is about. Evidence recovered on the Losi Center rooftop consisted of the screwdriver and then also that shooter's perch. She described the perch as being easy to see at night using oblique light. Also identified what she called swipes on the northeast edge of the rooftop, like ledge of the rooftop. Same area as where the shooter had, the person on the video had dropped off the corner of the building. By swipes, what she's talking about is a hand mark or some other kind of disturbance. We had heard the first guy, Bagley, said, he was over there, he saw the footprint, he looked up, and he saw scuffs near the top. So seemed like just a variety of disturbance marks like that. They're calling swipes. And she says this one was right on the edge of the rooftop. Then right below were some other swipes and impressions. And then below that, there was a glass window that had latent prints on it. So first, starting with the perch. From the measurement from the perch to the tent, it's a total of 415 feet. But to account for the angle of the downward angle, this is we're in the hypotenuse of the triangle. So if you take away the drop and just get the long side, it's 410 feet with a 68-foot vertical drop. I haven't done the math on the trig, but we have what we need to be able to do that. 68 squared plus 48 squared should equal 415 squared if she's got these right. They also found the shoe impressions on the rooftop, as well as, and so they collected the prints and the shoe impressions. Didn't describe how she did that, how they collected them. The prints, presumably, standard lifting, but shoe impressions, how would you do that? A little curious about that. Is there some kind of like plastic or something, some kind of mold that you use? Just interested in their technique to get shoe impressions. At this point, there is a stipulation that is read into the record, meaning both of the parties have agreed that this can be said. The stipulation is that the investigators observed latent fingers and a palm print on the window near where the person of interest had dropped down from the roof. So we heard that. Swipe on top, swipes below, window below that with latent prints. Alyssa Farmer, who is an FBI latent print examiner, examined them, found that only 3 were of value for comparison purposes, and Tyler Robinson was excluded from those prints. Other prints that were found on the window were not suitable, and so ultimately the result of those exams were inconclusive. But the ones that could be examined, they're not Tyler's. He's excluded. It's not a very good frame-up. It's not a very good frame-up. Had him right there in custody and you couldn't like fake transfer a print. No, he's excluded. She then describes the courtyard, how she remembered there being like 5 or 6 levels that she described as steps with grass on them. The tent is on the west end. It's got some barriers around it and some banners and things like that. So that area is the next area that they processed. Again, took photographs, examined the tent area to see if anything else is there, and the FBI processed this part of the crime scene. Then we talk about the wooded area. So the wooded area we identify on the map. It's northeast of the Losi Center. It's across from Campus Drive in the big poster board map we have. It's roughly in the center of the map. There's Campus Drive does an S-curve, and it's just like right past the S-curve across from the parking lot. South of the road and the wooded area is where you find the computer science building as well as the parking lot. And then there's a walkway from the science building that gets to the Losi Center. In the wooded area, a rifle wrapped in a dark towel was found. So she got a call a little bit before 6 o'clock from the Utah County Sheriff's Office. They searched this area. They were searching this area because the surveillance video, the UVU surveillance video that showed the person coming off the rooftop, jumping down, showed them going in this direction, crossing Campus Drive, and then they are out of the camera view. And out of the camera view is the wooded area. So they went to search that. She gets this call a little bit before 6 from the Utah County Sheriff's Office, and she's told that they found a gun. So she told them to hold the scene, and she or the FBI evidence response team would respond, and ultimately she went. And so she saw the weapon. As far as while it was in place, she said she could really just see the dark towel. And so what they did is they photographed it in place, then they removed it, photographed it, and it was the condition that it was in. And then at that point, it's a towel. See, it's a towel that's used to wrap the gun. Now, I was a little bit confused by this testimony because I'm like, if all you can see is a towel, then how did they know they found a gun? But it became clearer when we see these photographs of the gun. The barrel comes out of the gun. So the barrel is visible. The towel is wrapped largely around the stock of the rifle. But the end of the barrel is coming out. So that's my best guess. But I would be curious from whoever it was that found it. I would be curious. How'd you know that was a gun? So everybody else, it kind of, you just saw a towel. And then when we get the photographs, like, you hardly see anything at all. First photograph, I couldn't see anything. She's like, you can sort of see the towel. If you say so. Perhaps you can. I could not see a towel. The second close up, you can kind of sort to start to see maybe a little bit of a towel. They weren't good photographs, and she kind of threw the FBI person under the bus for that. They took the photos. Sorry. So we see them first, just kind of what she says is a towel under the bushes. I see a bunch of bushes, with some shadowing underneath. Then closer, she calls a mid-range shot of the towel in the bushes. So they probably did do, variety of ranges, got real close to it too, and did a close-up, but they didn't show us that today. So the FBI special agent removed it from the bushes. She put it on a box next to the photo and put it on the box so that they could photograph, and then remove the towel, packaged the towel, and then secured the gun so that it would be made safe. So we see these variety of photos. First, like I said, the bushes, and then next we see the towel wrapped around the rifle in the box. Like I said, the barrel is kind of sticking out. And so that photo is to document the condition it was in when it was found. Next photograph is the rifle in the box. The supposed stock photo that New York Post published, way back in the early days. No, it's this rifle in that box. It was pretty clearly an evidence box. By making it safe, what she means is verifying that there's nothing in the chamber. There's no cartridges in the gun that could go off. So that just means you have to pull the bolt back, remove everything in the chamber, and clear it. Explains the bolt action means the shooter has to pull it back and forward to do the loading and extracting. A semi-automatic does it all with the pull of the pistol, pull of the trigger. It's not really just the pull of the trigger, it's the slide action and all that stuff, but whatever, It happens automatically when you pull the trigger. Just pointing out, emphasizing the bolt action does not automatically extract the casing like a semi-automatic does. So she found in the bullet one fired 30-06 cartridge case, as well as 3 unfired cartridge cases, and they all have engravings on them. They all have the engravings. We get some language clarification. The cartridge is the whole round, the complete thing. It's got the metal case that holds the primer, and it holds the powder, and then it's got the bullet on the top. It's the whole thing. When you talk about the casing, you're just talking about what's left after the bullet's been fired. The primer's been struck, the bullet's been ejected, the powder has been exploded, and now all we have left is the casing. So just the difference between fired and unfired. She was able to see the engravings at the scene. So the towel was packaged and provided to the FBI. The firearm was also packaged and provided first to the FBI, then to the ATF. Same with the cartridge and the casing. Everything was tested, photographed, etc. We got photos from the ATF of the cartridges and the casing. It says they accurately captured the etchings. We get to see the etchings. We already know what they say. Mainly just kind of interested in the handwriting. It's a Dremel tool. I don't really expect it to be very good. But even with that, it's rather kindergarten-y, I feel like if I'm gonna inscribe something on metal, if I'm gonna try to engrave something on metal with a Dremel tool, I'm gonna be using all caps myself. I'm gonna try to be like squared, with my with my tool. It just seems like it would be easier than like try to like curve things or anything. But just normal script. Kind of, yeah, just kind of like high school looking script. I don't know how to describe it. So after leaving the university, which was in Orem, she then went down to St. George. was the next thing that she did in the case. And she oversaw the execution of the search warrants at both residences. She was aware that Tyler was arrested, fingerprinted, etc., at the Utah County Jail. His clothing and all that stuff, anything in his pockets was packaged, taken into to evidence. He was wearing the maroon shirt, she identified. The homes that were searched were the home shared by Lance and Tyler, as well as Tyler's parents. So they start with Tyler's house, where they collected the Dremel tool and bits. Found 2 Remington 30-06 ammunition boxes, 30-06 cartridge cases, some long guns, a revolver, some burnt paper, clothing, shoes, 2 pairs of shoes, Converse gray and white, size 10.5, and also gray shoes with gray laces that were a different size she didn't remember. Reiterates the cartridge cases that she found are 30-06. So first we look at the casing and the bullets that she found. These were found in the spare bedroom that is next to Tyler's room on his side of the house. She describes the layout of the house as there's stairs, and then you turn one direction. I think it was left. You get to one side of the house where there's these 2 adjacent rooms, and that was kind of Tyler's side of the house. If you turn the other way of the stairs, you get to Lance's room. So this cartridge was on the spare bedroom that's next to Tyler's room, and it was on top of a safe. And it has test shot engraved on it. Test shot. I had it backwards. I put it in my notes. Right on the stairs goes to North, goes to Lance. Left on the stairs goes to Tyler's, goes to the southwest side. 4 total cartridges that she found. 5, actually. I take that back. 5 total. I think these are the case. I think she's saying 5 total cartridges that she found. Oh no, okay, I take it back. Sorry, guys. Casings, 5 total casings. 1 of them was engraved. All of them are 30-06 Springfield. Interestingly, there is no 30-06 weapon in the house. No obvious reason, everything else being equal, for those casings to be present. In a closet on the first floor, she also finds some shooting targets with perforations. These are targets that have the big bullseye in the middle, and then 4 small bullseyes around the corner. Yeah, it's got shots. It's been shot. There's a Dremel tool as well in the closet with the bits container. So the Dremel tool is with the targets. I did think that was a little interesting. She describes the Dremel tool. It's a handheld device you can use to make etchings. You put bits in it like a drill. So she photographed all that, packaged it, sent it to the ATF to test. We then see the photograph of the targets, and there's 3 of them. What I noticed about these is at least vis-a-vis the main center target, the first 2 on the left, his error was kind of to the left and up of the bullseye. The third one, his error was to the right and down. So it kind of looked like, he was trying to compensate for either his sight being off or just him not being a particularly good shooter. I mean, whatever. That's kind of what it looked like to me, is that his tendency was up and to the left, and so maybe he's scoping in the rifle. I'm really not sure, but just noticing that difference, like, oh, that looks like some kind of compensation. Maybe not. It's just what it looked like to me. A lot of comments in the chat. His groupings weren't bad. Not bad. You don't know the distance. That's the challenge. If this is from 1,000 yards, it's an amazing grouping. Because from 500 yards is probably a really good grouping. If it's from 15 yards, you probably kind of suck. Pretty sure even I could hit the bullseye at 50. Depending, maybe, not sure. I'm not that experienced with guns. I have shot a 30-06 though. I have shot a 30-06 back at my old grandpa in Montana's house. If you have a grandpa in Montana, surely you have shot a 30-06. It's like a rule or something. You grew up reading Patrick McManus and you shot a 30-06. But I was never a hunter. It was never really my thing. And I didn't particularly enjoy shooting the 30-06. It's not fun for, I was like 8 at the time. Not a fun gun for a small person to shoot. Much preferred the 22. Anyway. The perforations in these targets were consistent with bullet holes. She described it as all within the 7, 6, or 8, 6, 7, or 8 rings from the bullseye. There's various, targets that are on the target. So then we move to the burnt note found in the kitchen trash. She collected that, sent it to the FBI, photographed it. We get a photo of it, and yeah, it's burnt paper. It's burnt paper. You can barely tell that there's writing on it. It's got paper lines. There's, all this char. Hard for me to see writing. So hard for me to confirm this is the same note. I'd want to see like part of the writing on the note, ideally, depicted on the still intact part of this piece of paper. I couldn't see that in this photograph. So I don't know if it's there. Forensically, at least in theory, they would have other ways to connect the paper itself, potentially, but I don't know that that's super compelling because, like, if you've got a notebook or a pad of paper, you have many pieces of paper from the same thing. Just because you wrote a note on one piece of paper doesn't mean you couldn't burn another piece of paper and they would both forensically look like the same piece of paper. But, they're not. So that, I don't know if that's an issue or not, just something I kind of noticed. Not entirely sure it's solid proof that this is the note, but we did just get kind of the one photo. We're looking at it, of course, in the TV in the courtroom from home. Possible, but it definitely wasn't obvious. Let me just put it that way. She had seen the image of the note from Lance's phone, and so her argument is there's handwriting over on part of it that is consistent with this note. It's on Lance's phone. So at this point, Mr. McBride is displaying into the courtroom. He wants to put up a side-by-side of the photograph note from Lance's phone, which we didn't get to see before, not published, with this burnt thing. And so there is this brief moment where he has pulled it up on the screen that's visible to the gallery, but the camera has been on the screen. We've been looking at the screen. And so the camera catches it very quickly, but certainly long enough for it to be captured. It was clearly not intentional. Hard to say kind of who was at fault. Not sure I can blame the camera guy. He didn't have any notice that something new was coming up on the screen. Did seem to try to move it when he could. Probably Mr. McBride, who should have made sure, if it's only publishable to the courtroom, that, it either wasn't on the big screen, at least at that point, or that, verify the camera is not on the big screen. So probably this is Mr. McBride's fault to the extent, we need to point fingers and everything. But it was very brief. Nevertheless, enough for it to be screenshotted, and now it's out there, and I've already seen it on X and everything. So anyway, and then once again, like, we've seen the contents of this note. All I cared about was the condition. That's what I wanted to see, was the note intact. And it was. This was the unburnt note. That's all I cared about. We know the content. So the secrecy. Ugh. But anyway, the side-by-side that he did, we did not get to see. And I would have liked to have seen that because, this is presumably the basis for them saying these are the same document. And I wasn't able to see that comparison. So we then have some testimony that's allowed. There's like an objection and the testimony is allowed, but it goes mute again. It goes mute again. They mute freaking testimony. What is happening? What is happening? This is bizarre. This is just bizarre. So now I'm like really super pissed. Now I'm absolutely, absolutely ordering this transcript. This is some bullshit. Can't believe there. And this is, by the way, this is apparently confirmed. KSL puts out a notice that this is by court order. This is not just like, oh, the stream went down or, oh, there was some tech glitch. The judge ordered muted for this part. Don't like that. They collected Tyler's car from his parents' home. They describe it only as a gray Dodge Challenger. I'm like, please give me at least the model year, trim, anything like that. Nope, just gray Dodge Challenger. She received several reports from the ATF and the FBI. And so that is where we go next. We start with the ATF's report on the cartridge case and cartridges that were found with the rifle. So this is DNA testing on the rifle as well. DNA testing on those items. Everything is they have, Tyler's swab for comparison. Everything else is swabbed. They compare it all. Get a variety of results. So swabs first from the stock and grips, as well as the bolt, which has possible ridge detail, meaning possible fingerprint. This one came back, male DNA, 1 trillion times more likely that it came from Tyler Robinson as the major contributor, plus 3 unrelated unknowns, than that it came from 4 unknowns. So we have a 4-person mix on this one. Major contributor, Tyler Robinson, they say. Second item, butt plate. The butt plate of the rifle, this is the end that sits against your shoulder. This one, male DNA, 1 trillion times more likely to be Tyler as the major contributor, plus 4 others than 5 completely unknown, unrelated people. 5 and on a gun that's known to belong to the family, grandpa's rifle. That's sticky. That particular one is sticky. That's going to be, I anticipate, probably a problem from scientific standpoint. But I am so eager for this hearing. I know so many of you all are not. I can't wait for it. I can't wait to hear about all this. Like why the 5? Like how the validate, all that stuff. I can't wait to hear this. I'm very excited. But I do know 5 is a problem. And if you've got this complication of possible, relatively close relations, that one is a tricky puzzle to figure out. Next item was swabs from the trigger and the trigger guard, as well as with possible ridge detail. We haven't heard any like FBI latent or ATF latent examiner, so don't know if that's because this possible ridge detail never panned out, wasn't comparable, anything like that. We didn't get the report. We're not hearing anything about it, so I'm kind of assuming not a lot there to work with. This one came back 1 trillion times more likely to be Tyler plus 3 unrelated individuals than 4 unknown unrelated individuals. So now we have a 4-person mix. Getting closer, still at kind of the limits of what star mix is generally validated for, but is that complicated by the possible, maybe even likely contribution of a family member to the mix? Don't know. Can't wait to hear. Next item was the 30-06 cartridge from the gun. I think this is referring to the casing, the cartridge casing. This one was 1 trillion times more likely to be Tyler as the major contributor, plus 2 unknown unrelated individuals than it would be to be 3 completely unrelated unknown individuals. 3, getting better, getting better. Next item was from the barrel, swabs from the barrel, as well as one of the 30-06 cartridges from inside the firearm. Again, trillion times more likely it was Tyler as the major of plus 2 unknown unrelated individuals than that the whole thing is 3 unknown unrelated individuals. Last item, scope, swabs of what she describes as, again, ridge detail on the scope. This came back 6.28 billion times more likely to be Tyler plus 3 unrelated unknown individuals than to be 4 completely unrelated unknown individuals. So less, lower statistic tends to suggest less genetic information, probably partial profile, not a full profile. The others, are all consistently 1 million. So I think, or 1 trillion. So maybe more likely to be a full profile, but complicated by this issue that all of these are mixtures. Why are all of these mixtures? What does that mean? Is the defense going to make hay out of that? They're certainly going to try. Certainly going to try. Absolutely. But we're just too good at detecting DNA now. We're too good at detecting DNA. We can pick up all of the transfer, the environmental background, the contamination, all of it. And so it's just complicated the picture of being able to interpret what the significance is of the presence of DNA on something, because there's a lot of ways it can get there. It can persist for a long period of time. And there's no way to be able to kind of say, how did it get deposited? When did it get deposited? Sometimes you might think, oh, we have a major contributor and some minor contributors. And so the person who contributed the most amount of DNA, that's probably the last person to handle it. But it's not that simple, because for a whole variety of reasons. But one of the big reasons is because people have different profiles vis-a-vis shedding. Some people are shedders. Some people are less inclined to shed. And this is just, the amount of DNA that you are going to tend to leave in sweat or skin cells or just whatever when you touch an item. That greasy guy over there may be more likely to be a shedder. I don't know. But so you could have a situation where you have somebody who's like a really heavy shedder, they touch the item, and then a month later somebody who is not much of a shedder at all comes and touches it. You have the major and the minor. Would not be right to interpret that as, some kind of temporal indication. But the defense is going to try to make hay out of this. No question about it. There's other DNA on the gun, and they don't know who it belongs to. This might be an area where the the defense does kind of try to maybe do some independent testing, see if they can develop or get more information about any of these individual profiles. That would potentially be a good use of next gen technology. Help them develop an alternative suspect. Anybody else that they can point the finger at? Because I'll tell you, the obvious for the defense, I think is pretty clear, is Lance. Obvious tool, way to point the finger, try to generate doubt would be Lance. Point the finger at Lance. He looks a lot like Tyler, just for purposes of the, the video, the surveillance video. He has access, they live in the same home. So like in theory, he could get access to Tyler's phone, take his car, maybe. If they could put Lance's DNA on any of this, the guns, cartridges, all that, oh, they're having a heyday. They're going to start to be built, going to be starting to build, try to build an alternative suspect defense. And it wasn't me, it was him. Maybe. Because it certainly helps too with the text messages and all that stuff, that's with Lance. I don't know. Can't say I see a real strong pathway for that to win, but just depends, I guess. Depends on how it unfolded and what they could pull off. But it seems like an obvious approach to at least explore and see if there's anything there. We then move to another report, which is based on, it's the one that we already saw, the one that was in Exhibit 2, where they did the tool mark analysis of the cartridge case that was found inside the gun, which not surprisingly matched the gun. That's not a shocker at all. But then also the bullet fragments from the autopsy and the jacket casing. So we kind of work through this report. This is all the stuff that was found in the gun or the gun itself. Sorry, hang on. We have in this like test round, we have the cartridge and the casing and the unfired cartridges that had been found in the gun in the wooded area. We have her test fire cases. She finds tool marks on two of these items that are consistent with engravings from a rotary cutting tool, consistent with something like a Dremel, suitable for comparison to a suspect tool. We then have the bullet jacket fragment and the other fragments that were recovered from Charlie Kirk at his autopsy, consisting of a .30 caliber class deformed jacket fragment and 4 lead fragments, which now we got to see. And that was, I thought, quite insightful. The jacket itself was neither identified nor excluded. We already know the class characteristic matched the caliber, but there were insufficient individual marks to either rule in or rule out, so the result is inconclusive. And as far as the leg fragments, they are not suitable for microscopic comparison. So there's nothing that can be done there to try to trace them, connect them to the firearm. Time for me to change teas. Next up is the ATF's biological report. This is a DNA testing that they did on the cartridges that were found on the safe, as well as the Dremel tool, the bits, and the casings that were recovered from Tyler's home. So 4 swabs from the buttons of the Dremel comes back 1 trillion times more likely to be Tyler as the major contributor, plus 2 others than 3 unknown unrelated. They also included this this is the only one they had this other statistical kind of disclaimer where they said the probability of an unrelated person in the population, like matching this profile, is less than 1 in 1 trillion. I'm very intrigued by this statistic and want to learn more about it because this is, on its face, a population statistic. And it's one that would mean the likelihood of finding an unrelated person with this profile is, you know, there are fewer people you would expect to find with this profile than have like really existed on the planet since its inception. So that's pretty strong identification. But I don't know how they got to a population level statistic, because typically I don't have the capacity to do that. So I am curious to learn about more. That's a little nerd thing on my part. We have swabs from the cord, swabs from the metal, the bits, and then swabs from the etched 30-06 case that was from the safe, the test fire cartridge casing. This came back 1 trillion times more likely to be Tyler plus 2 unknown unrelated individuals than 3 unknown. We're still dealing with all mixes, not a single source profile yet in this case. Next report is the tool mark report. And so this is comparing the 5 30-06 cartridge cases that including the unfired cartridges that have the engravings on them. First, we have the test shot. She looks at, there's tool marks on that that are consistent with the rotary cutting tip. We have exhibits A and E, A through E, casing. These are the casings that were on top of the safe. And then she says 18 A through E, and one other item that she didn't remember what it was, what 16 was, which is probably not helpful. But for our purposes, test shot is fine. And the other casings from the house, those were identified as being fired from the rifle. So she's saying, in real squirrely tool mark bullshit fashion, it's from that rifle, but I can't say it's from that rifle. We have the tool mark examiner, so I'm going to hold off on my tool mark rant until we get into Mr. Burt's examination of the tool mark examiner. I swear, I'm going to hold off most of my rants. Then the metal bits that she looked at, as well as the casing that had been found in the gun and the unfired cartridges that were found in the gun, as well as the cartridge that was on the case, identified the Dremel tool as having made the tool marks on all of those cartridge casings. It was the one bit, I believe it was the longest bit that she collected that was associated with having made those tool marks, she says, identified. Next, we go to a video, like a portion of a video of the UVU surveillance, back to the shooter dropping off the roof, the not enhanced version, the raw version. Mr. Burt objects to relevance at this point. He wants a proffer. So Mr. McBride explains, we've heard testimony about prints on a glass window, and this is going to show the suspect's behavior in the area. So they watched the video of the suspect on the rooftop and can't see anything. So her testimony is that when she first saw this video, you couldn't tell if the suspect touched the glass or not because it was very grainy. But then they got the direct like the, the raw file, video file from UVU, and from that you could zoom in, get a better picture, and they were able to see that that person did not touch the window. So the prints not belonging to Tyler isn't because the person on the roof they say wasn't Tyler. It's because they say if you do the zoom, you can see the guy coming off the roof didn't touch the window. So the guy on the roof isn't the source of those prints. Mr. McBride is now done with this witness, and so it is the defense's turn. Asked if she would characterize herself as like a traffic manager for the evidence, she said, "That's a good way to put it. I love this lady. I do. She's great. She's great." We go to a 229-page report that SBI wrote, and we start to work through it. We start with a report from September 22nd, which gives an overview of the various scenes that they responded to. So first we talk about the Fulton Library. We haven't heard about the Fulton Library before. So why was that considered part of a scene? She said initially officers were trying to find the route of the shooter, and there were unattended items at the bus stop, which I guess is probably at or near the library. It was away from the courtyard, and they were thought to be suspicious. It was a backpack, a jacket, some gloves, maybe some other things. It was seized and sent to the FBI lab for processing because they thought they might have been items that the suspect shed while the suspect was in flight. Abandoned, tossed. So they didn't know if it was probative of the time. She herself, she's asked about communicating to the lab to stop the testing. She says she doesn't remember doing that communication. But in any event, lab reports apparently have the items listed, so they did apparently make it to the FBI, but it was eventually determined that they were not related to the shooting. Next, a report on September the 24th. This involves a search for request for search of firearms. This is a NIBIN request. This is the National Integrated Ballistics Information Network. This is the CODIS for guns. This is the CODIS for guns. This is a 3D scan based technology. And so what happens is when they do their test fires in these labs, so that they have something to compare to the forensic item that they're looking at, they enter it into NIBIN, and then they have this database of all these tool marks on casings, and they run against each other. So it looks for a match, looks for similarities. Has to be verified by an individual to do the iMagic voodoo. The computer isn't good enough. Must have the voodoo eyes to make it all legit. But anyway, the computer is meant to alert them to possibility that they can go verify. So it was run through the test fires in this one to look for matches. Got nothing back. Nothing hit. So gun hasn't been used to commit any crimes that left evidence in any recent years. Clean gun. We talk now about we seized the towel back in the wooded area. She apparently said we. I didn't even notice. Mr. Burt noticed. She said we. So who's we? And she explains it's the SBI and the FBI evidence response team, specifically her and Special Agent Michelle Kunacki, I think was the name, Kunacki. And as far as like who actually did what, she's the one who grabbed it, meaning the special agent. Miss Falmuina was there. She was observing. They communicated. And so this was like impeachment by, so you just watched. Well, yeah. I guess. I'm not sure. I'm not sure why that mattered. Why did we do that? I don't think it mattered. Mr. Burt is a extended cross kind of guy. He's a long, lots of cross kind of guy that you get lost in. And that did kind of surprise me because technique wise, I consider that weak. You lose too much with a long cross. You get bored. It's not clear what's important and what isn't. And then as soon as you do something kind of stupid, like we're arguing about what we means, it's like, okay, well, now I know you're just kind of trying to nitpick and be sort of annoying. And I'm going to be more inclined to tune it out. So I'm kind of surprised that this was his approach. But it's not uncommon. It's actually probably more rare to really find a good, consistent, disciplined, short cross-examiner. Somebody who really does consistently keep it to like 5 questions and sit down. And because they've prioritized what matters, those 5 questions are about things that matter. So they're all punchy and they all stick with you. And it comes across as impactful because it's just like boom, 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 sit down. And so there's no time to be like, oh, well, what's with all this bullshit? It's hard to do that. You have to really, really edit. You have to really work your case because it all has to fit together. You have to let things go that might be important for a different theory of your case, but for the one that you have, doesn't really matter. Stuff that like, it's available, it might tempt you. You have a particularly obnoxious witness. They say something really stupid. You have the ability to impeach them with it, like clearly, directly, but it's about something that doesn't matter at all. Gotta sometimes just let that one go. So it takes discipline to do that, and it takes a lot of preparation to do that. So it is probably more uncommon, but I'm just telling you, it is so effective. So effective. I would love, maybe I'm gonna, maybe sometime I'll try to see if I can find good examples. Like I learned this from I said on the stream today, from my old trial practice professor down in San Diego, who was a long time high level San Diego County public defender. And he'd done several high profile cases. They are televised, some of them. This was his method, and good Lord, it works. It's very effective. I'm gonna maybe see if I can go back and find like one of his old trials. That would be fun. That might be fun. Watch that. And then you can see what I mean. And we can compare it to something like this. Anyway, that was kind of an aside. So as far as now, yeah, the photos of the bush. She's like, well, the FBI took those. That's all we got. She does believe that one officer had a body-worn camera on at the time. She had not seen it. So Mr. Burt is concerned about, documenting the discovery of the firearm. So maybe on body-worn camera, but she hasn't seen it. There's kind of some back and forth about the rifle. Mr. Burt seemed to think that they took the towel off the rifle and then put it back on. She says, no. The photograph, it was, it's still wrapped in the gun because the entire time the gun was wrapped in a towel. So they took it out the way that it was. She grabbed both the towel and the gun. She grabbed the gun, wrapped in the towel out of the bushes the way it was, placed it on the box as it was, photographed that, and then only then removed the towel. So that got sorted out. Not clear if, again, Mr. Burt thought he had something there. I mean, I guess he probably did, but she has good explanations for that. Then again, the quote unquote, we processed other crime scenes. She was personally involved in coordinating all of the searches, but she was not always personally present when she uses that term. So it is the teams that seal, bring the evidence back to the command post, and then they have a conversation about who's going to take custody of it. Where's it going to go? She did not personally observe the seizure of the screwdriver. That was the crime lab response team, 2 people from that team. She first saw the UVU video on the September the 10th with the shooter. The windows were processed on September the 11th, the next day. So they wanted to rule out the suspect touching the window. That was why they processed it. So she was not personally present the whole time for that either. September the 24th, they did forensic analysis. That's summarized in this one. There's another report, says a 5th report about the progress of testing. Then there's another report that documents a firearm seized and traced at River Street that led to nothing of value. I don't know what that's about. Got a latent print report back from the state crime lab, and that details the results that were in the stipulation. The window, not a match. Tyler is excluded. And then there is a transfer of evidence from the FBI to the SBI and reports summarizing the forensic reports. Then the whole larger 200 and whatever it was, 90 some page report also involves interviews of people who knew Tyler to see if he had hostility towards Charlie Kirk. Apparently did a lot of interviews of people that knew Tyler. She was not involved with that. And then they monitor his mail and his jail communications. Not surprising in the least. Asked if she is aware if that's produced anything of value. She is not keeping abreast of that. I'm reasonably confident it's not, because the first thing you tell your in-jail client, do not say a single word over that telephone. Do not say a single word to anybody coming to an in-person visit about your case. Talk about anything else you want. Do not talk about your case, because everything is being monitored. Don't do it. Just don't do it. So if he has followed that advisement, that is only unusual in the sense that it makes him very good at following instructions in a way that far too many people in jail are not. They literally tell you on the phone, like, you pick up the phone, it gives you, somebody from the jail is calling you, it tells you it's going to be monitored and recorded, and do you accept the call? And you have to affirmatively accept the call after getting this advisement. And then they sit there and talk all about their case. It's just, it's madness. It's insane. They sit there and commit the witness intimidation on the phone, If you show up, so-and-so is going to come and cause you problems. Literally right there. We're talking not the smartest people, okay? They're in jail, remember, because of the 20 kilos in the trunk that they're like, sure, go ahead and open it up. What did you think was going to happen? With this, the defense is done. The state is done. Mr. Grunender just wants to verify all the exhibits are admitted, so they go through the list and compare their lists. We have these omissions from the exhibit list that I just couldn't help but notice. There's 17, 18, and 26 through 29. They weren't even itemized on the exhibit list. The state's not offering them. What are they? There's some secret exhibits. Some things that they thought about offering but didn't even put on their public list. We don't know. We don't know. At this point, the state rests. The state rests. They have a brief sidebar. We then go to Mr. Nyman, who reiterates his request that the families have asked that all exhibits be shown here in open court. So he's asking the court to reconsider its prior ruling. He wants to display publicly the 12.1, which is the enhanced video, because all that we saw in court was the unenhanced one, and you can't see anything. This is the guy going across the roof. He says the family should be able to see it as well. It can be addressed in voir dire as far as prejudice purposes. But the problem is for the family not seeing, that doesn't have a cure. So the prejudice to the defense can be cured, but the prejudice to the victim cannot. I thought that was a very good argument. Very very well put. Mr. Grunander did not oppose. We favor transparency. Mr. Burt, now again with the irony, we're asking the court to keep the focus on the purpose of the hearing, from the guy who boiled the frog into an old, chewy, dry boot yesterday with his DNA cross-exam. Well, we're here to keep the focus on the purpose of the hearing. It's to determine the defendant's guilt, which it's not, by the way. It's to determine probable cause. That was like a misstatement. Let it slip. That was not the best way to put that, because now you've conflated these two things, and there's going to be plenty of people already who've made up their minds after this, and I understand. Public opinion is not the courthouse. You're not obligated to give anybody the presumption of innocence. I do like to wait until they've had the chance to tell their side, just to be sure. You don't want to rule out that they've got a side. I'm not saying Tyler Robinson is guilty. I'm saying it looks like a hard case to defend. I don't know, because I don't know what they have. The point is not to determine the defendant's guilt, definitely not, but also not to educate the family, not to educate the victim or the victim's family, not to educate the world. That's not why we're here. Oh, the irony. He also says they have witness availability problems, and we've spent all kinds of time arguing about the rights of third parties, and it's not inappropriate to make this ask, but we need to get through our witness. And then Erica Kirk calls her out by name. Erica Kirk, Mrs. Kirk, she's been adept at holding press conferences where she has revealed evidence. She's called the state's lawyers her lawyer. She's seen all the public evidence. So they have the ability to go outside and have a press conference and say whatever they think it is. I thought this was a major misstep. Major misstep. This was not necessary, and the problem is that even if you take issue with things that Erica has said, you're so much better off keeping it factual, keeping it dispassionate, not getting bitchy like this. Adept at holding press conferences? I don't recall she's ever held a press conference. Sure, she's made some public statements. She's revealed evidence. What evidence has she revealed that's not already public? What has she revealed? All of this seems, this is like, I understand what he's referring to. Yeah, she's made some public statements. But these are, at best, exaggerations and, again, characterizations. His viewpoint of it, which is obviously quite negative, which I expect. He's the defense guy fighting the publicity. But at worst, it's like a real serious distortion of what the truth is, of what she has actually said and done. And they can go outside and have a press release and say what they think it is. What even is that about? She's asking to see, not to talk. She doesn't need your permission to talk. She knows that. I was really surprised at the bitchiness to Erica. I don't see what the upside was. I really don't see what the upside was, because you're not getting the judge on your side with this. You risk that now the judge is seeing you differently because you've gone in and you've attacked a victim unfairly. Mm. There's no question that sometimes, as a lawyer, as a defense lawyer, you have to confront people who are victims of crimes, ostensible victims of crimes, known victims of crimes. Like, no question they're a victim. Sometimes maybe it's less clear, and that's the issue in dispute in the case. So you might be right, you might be wrong. You have to confront them with hard facts sometimes. There's no question about that. That's part of the job. But I just have never seen the upside to doing it like this. As opposed to just keep it to the facts. I'm not even sure why this mattered. This really just seemed like a serious overreaction to her asserting herself. I can imagine maybe he's resentful of her doing that, speaking up, participating in the case. It's not usual. Most states don't have this level of protection for victims. They don't give them this kind of standing. So maybe he's never run into this before, doesn't like it. Now he's got two adversaries on the other side, plus the media. But I just don't, I've racked my brain. Like, what on earth did he think he was going to accomplish with this? I question if it was strategic. I really do. And whether it was just he kind of lost his temper. Anybody sees a strategy here? I'd love to hear it, I guess. Because you do this in front of a jury, they're going to be side-eyeing you for the whole rest of the trial. You will lose a lot of trust. They don't like this. The judge is not going to like this. We already know the judge has a lot of sympathy for Erica. He's going to have a lot of sympathy for all victims. But he's given her this special, deference and recognition and all of that. And he knows, they all know, this situation is extremely traumatic. These people are suffering. She's suffered from the loss of her husband. She's suffered from being maligned in the online circles. And now you want to pile on too? You want to add to that? You want to contribute to that? The reason you keep it to the facts is to minimize the harm. In case you're wrong. Goes back to that epistemic humility. You better be pretty fucking sure you're right. If you are going to take somebody who is suffering and add to their burden. I learned that real fast. Real fast, because I've always Found a way to do my job in a way that does what needs to be done, but allows me to look at myself in the mirror every day and feel okay about it. I don't always have to love it. It's not always easy. I don't always like it. But I don't feel like an enormous asshole over what I did. And if I had done this, I am feeling like an enormous asshole. Really surprised me. Really surprised me. Mr. Neiman takes issue with this. Lots of what was said wasn't true. The judge now is the judge realizes we're about to go off the rails. So he cuts it off. I know you want to respond to everything. Please, we have to keep this to probable cause. Please, we have the time issues. Please be brief. Mr. Neiman just says, the family has not seen this video. They do not have access to the state's evidence. This is not about educating anybody. This is about letting the family see the evidence from this 10-month investigation where their husband and father was assassinated. You invited that, Mr. Burt. You invited that. Reminder. Just a reminder, because Judge hasn't forgotten. That's who you just went at. Why did you do that? The judge recognizes victims' rights, got to balance the rights of the parties, all of that. He's going to reserve and revisit it tomorrow because it's very important, but we are short on time. So we're going to not worry about it today. We're going to do it tomorrow because we have to get through Samantha Corner, the firearms and tool mark analyst for the ATF. Firearms and tool marks. What a joy. What joy. So the best thing I can say about Samantha Corner is that she is so much better than Melissa Oberg. As firearms tool marks analysts go, I give her credit for several things. I give her credit for acknowledging there are in fact problems with your discipline. There are criticisms with the discipline. Acknowledging the limitations of what you're doing here and respecting that. Very contrary to Melissa Oberg from back there in Delphi. Could not help but just have that comparison in my mind throughout this entire testimony. So she did the exams on behalf of the state. Exhibit 32 is her report. So first report she received, we worked through, she received the firearm, the case, the casing, the cartridge, bullet jacket fragment, the lead fragments. There's a characterization of the tool marks, rifling characteristic she looks for on the jacket. Her conclusions conform with the DOJ uniform policy, right? Remember, the state's rested, so this is Mr. Burt that's called her. We already know her conclusion. It's inconclusive. Inconclusive. The bullet jacket is inconclusive. The fragments are not. The lead fragments are not suitable for comparison. So once again, like we did yesterday, we go into this DOJ standard language policy that they have to use. And asked if they publish this because of criticism of tool marks analysis about basically overclaiming. She doesn't know because the policy was adopted before her time. She doesn't know when and how it came about. It is because of problems with overclaiming. So we talk about some of the limitations. The examiner's decision is not based on statistically derived or verified measurement, not based on comparison to all other fire marks or tool marks in the world. You can't assert that the conclusion is based on the uniqueness of this item. You're not to use the term individualized when describing a source conclusion, meaning the source of a mark. And she says, well, I did identify the cartridge case to the rifle, but she didn't use the language individualize. Says you won't opine that the identification is to the exclusion of all other sources. Won't say it's infallible. Won't say there's won't say that it's a zero error rate. You won't use any type of statistic or numerical probability for like how likely your conclusion is unless that is evidence-based, facts and math to support it. And you won't say that there's absolute or 100% certainty or a reasonable degree of scientific certainty. Won't use those words. So you see already a lot of overlap with the DOJ's policy that we heard yesterday. A lot of these same limitations deriving out of the same criticisms, because as we'll see, it all goes back to the same 2009 National Academy of the Sciences report and 2016 PCAST report that were both highly critical of a variety of forensic methods, but certainly tool marks. Tool marks were among some of the most highly criticized techniques in those reports. So we start with her 47-page case file, get that into evidence. She does take notes, but mostly it's for her initial impressions to show proof of her conclusions, but she has to document the basis for her opinions in the file. Mr. Burt wants it in. Mr. Bride thinks it's irrelevant. Mr. Burt explains it's the basis for her conclusions, and the report doesn't contain her reasons, so it's in there. Mr. McBride says without testimony about the meaning of the notes, it's just more confusing. And Mr. Burt says, well, I intend to talk about the comparison. So it's allowed. First off, one possibly interesting thing. She received the 1 bullet jacket fragment and the 4 lead fragments, and she's asked about a discrepancy in the number of bullet fragments that were recovered from the medical examiner. And did the ATF lose some fragments? Originally, seems there possibly were 7 fragments in the medical examiner's photo. She got the evidence that she got in a sealed envelope, sealed condition. So she can't account for any discrepancy. Don't know what that means. We didn't firmly establish there is one, but it's definitely implied. Don't know if there's an explanation. Now, we know from way back that the defense's January 9th motion, the one that was originally sealed, got unsealed, had this ATF report attached to it, indicated that they were, the motion was related to conversations about doing destructive testing, and that included potentially chemical analysis. And so that did cross my mind that I wonder if, did they keep some aside? Did they like take some of the lead because they were intending to do some kind of bullet lead analysis, which may or may not be good science, different techniques, lots of issues with it, but possibly maybe they kept some aside and then, you know, they were going to reserve it to do this testing, but because it's destructive, they had to do the notice. And then we got into this back and forth with the defense. So it's just sitting somewhere. Maybe could be an explanation, but I don't know. And if otherwise bullet fragments are going missing, that's not good. If bullet fragments are actually missing and unaccounted for, that's a big chain of custody problem. Not meaning that it stops the existing ones from coming in, but it certainly calls into question the handling and the security, doesn't it? So defense definitely wants me to think that's what happened. It's not firmly established here, but I'm going to be attuned in the future to an explanation. Is there a discrepancy? Did bullet lead fragments go missing? If so, has that been explained? We get to see photos of the jacket fragment. So first we see it in its original condition. It's photographed interior and the exterior. She cleaned it and then she, quote unquote, peeled the petals back. And so what happens is we're able to see, like from the photographs of all of these bullets and everything that were recovered, the ones inside the rifle and everything. This is a soft point bullet. It's got a copper jacket on it, but it doesn't go completely over the tip. The lead portion of the tip is exposed. And so the way the bullet is made to work is that it's made to mushroom and expand. And then the copper casing, copper is relatively soft. It peels back and the bullet mushrooms, and it does that to create basically a bigger wound channel, cause more damage, but also to stop it from going through. So when you get the bullet jacket, you know, it's peeled off because the bullet has mushroomed. It's peeled back. So she calls those the petals. So we have the photos of in the original condition, and then she has peeled the petals back so that you can expose the part that has the tool marks on it. And so, yeah, for her to see the lands and the grooves, which are the rifling inside the barrel, corresponds with, you know, leaves corresponding marks on the jacket, bullet jacket. And so I forget, the lands is the high part and the grooves is the low part. Pretty sure. Forget exactly, but pretty sure that's what it is. So that's what they're looking at to do this tool mark comparison. They're looking at the lands and the grooves and the similarity between their test fire and their forensic sample. To do that, it's necessary for the examination, and she uses pliers. This is, according to her, she's found it to work, and it is fairly normal to do this, to do the examination. No follow-up on the pliers, like, are they specialized pliers to do something like this? What material are they made out of? Do they themselves have, sometimes, you know, your pliers will have, I don't even know what you'd call it, but like texture, so that it grips a little bit. That might, you know, be a source of damage. No follow-up on the nature of her pliers. I was curious about it, but it didn't get asked. We also have the photograph of the bullet fragments. Now these, the photograph of the bullet fragments are with a ruler. And so I was honestly kind of surprised at how big some of these fragments are. One of them is like a centimeter, maybe over a centimeter. I mean, they're fairly large. So I'm sure that, you know, we saw the photo in court. I'm sure it's out there. But these are, at least that one is a pretty large fragment. She photographed, of course, all of them. They're deemed unsuitable for comparison because they don't have marks on them. The lead is the core. It doesn't come into contact with the rifle barrel at any point. Now the tip might during the mushrooming, but that's going to be more on impact. That's not from the rifle. Like if there was a problem and it pre-did, you know, maybe you'd get a mark, but that's not how the bullet's supposed to work. Not how it normally works. Normally the lead does not come into contact with the barrel. So no marks, no way to do a tool mark comparison with it. She photographed it again after folding the petals back, and again, the interior and the exterior. She's able to determine class. I should stop. Their methodology is to look for what they call class, subclass, and individual characteristics. And these are in kind of descending order of uniqueness. The class is common to lots and lots and lots of different things. Subclass is typically more like one or, limited manufacturing run of a same thing. The idea of subclass marks is that, okay, so you have a factory that manufactures 30-06 ammunition. Okay, you put out, I don't know what's a reasonable amount of bullets to make. 100,000 a day. 100,000 bullets a day go through your come through your factory. And so you have equipment that does that, that molds it, stamps it, shapes it, etc. And so those tools that are used to do that, those machines will leave marks on the softer material of the lead. So you have general class characteristics, which are going to be things like the size of it, shape, maybe, different things that are going to correspond to types, broad types. But then in the manufacturing process, the idea is that over time, there's going to be wear on your equipment. And so as the 100,000 bullets go through day after day after day, each one is wearing them. And at some point, you're going to reach a point where the wear is going to create different marks from the manufacturer on the bullet than the very first one did. And so that's subclass. If you can identify that, it'll tell you maybe it's part of this manufacturing run. Limit it from the larger class of all of the 30-06 bullets coming out of your factory. But it's not enough to individualize it. The problem is that the whole voodoo of enlarged, there's a lot of voodoo with tool mark science, but a big part of it is there's no like standard for telling what's a subclass measure marking and what's an individual marking. There's no standard. Look it up. Look it up. Try to find like, how do you define like what's the formula? How do I know? What do I look for? There's nothing. It's literally just, you kind of learn that. That's what the training is about. You look at lots of things and you sort of get a feel for it. This is super voodoo stuff, guys. So that's the broad, what they do, what they're looking for with their comparison. So yes, class, least restrictive, that will include things like diameter, number of lands and grooves, the twist, the rifling characteristics. This she described as 6R conventional rifling. That means 6 lands and grooves that twist to the right. Second thing, she describes a subclass based on, the manufacturing features, like we talked about, certain state of wear. And then the individuals are irregularities from either manufacturing or from wear to the tool, so the firearm itself, that would be distinct to that tool. So if you have a gun that's an old gun and there's like part of the barrel got, I don't know, chipped or something, it got dinged. The idea is that's going to leave a unique mark on the bullet that's going to allow you to notice it, to see it, because it will consistently do that because it's a permanent feature. Your test fire will have it. Your regular bullet will have it. And you, the voodoo priestess analyst, is going to be able to see that mark and know that it's individual to that firearm. Just because you've looked at a lot, and so you're really good at telling those differences. That's kind of the idea. Caliber is part of the class. It can narrow the range of firearms that could fire it. So in this particular case, she got a range measurement for the diameter of the bullet because it was damaged. It was not like a perfect circle. So she got the kind of minimum and the maximum diameters of it. It was a range of 0.286 to 0.301 inches. Now this was interesting. There's all kinds of charts out there for bullet diameters that you can look at if you're interested, because there can be crossover in like different sizes and stuff like that. There can be ranges like within a certain caliber and stuff. But the next lowest down behind the 30 caliber is the 7mm, and the maximum diameter for the 7mm is 0.284. So just below the lowest possible diameter of this one. So that's why she was able, I think, to call it a 30 caliber, because even the lowest possible end of the range is still higher than the next lowest caliber that is available. So 0.286 to 0.301 inches in diameter. She measured the land impression width. Yeah, it's because of the damage and deformity, she couldn't get the exact circle of the diameter, so that's why the range. General rifling characteristics, searching that will show you guns that could produce those particular characteristics. And so there were several different 30 caliber guns that could have fired this gun based on this bullet based on those characteristics. We see the chart, got a whole bunch of different things on it. There's even a pistol on it. There's bolt action rifles. It's not the longest list I've seen for stuff like this, you know, when you have I remember a case. I remember a case pretty recently that that was really the issue, was the tool mark stuff. And I mean, it's like 50 guns long, this list, number of guns that could have produced, you know, could have fired this from the class level. So it wasn't that long, you know, as I've seen, but it's obviously more than one. And of course he calls out, oh, the Mauser. Mauser's not on that, right? Mauser's not on that. The Mauser 98 isn't on it because the Mauser 98 wasn't originally chambered for 30-06. The 30-06 is a retrofit. It's a modification. It's a new barrel that they put on that gun after the fact. So of course it wouldn't be on the list. But he did make sure we saw that. We talk about how the subclass can be confused. Subclass characteristics can be confused with individual characteristics. Yes, that's the whole point. She says they can be similar, but trained examiners can tell the difference, which really does sound a lot like using her subjective experience as a substitute for foundational validity of the science. Trained examiners can tell. Why? Well, you just can. You just can. You've looked at a lot. She says that subclass characteristics are uniform. They tend to be spaced uniformly. They look almost exactly the same every time. I don't know what that means. I don't know what that means. There are procedures for all the different types of examinations that they do and documentation that's required. So they're always supposed to evaluate the potential for subclass characteristics. In this case, you have stria within the lands and grooves, and they have starts, they have stops. What that means is, so what she does, you put the bullet under a microscope, or the bullet jacket in this case, you put it under the microscope. You look at the markings, and then, you know, the lands and the grooves, the twists. Generally, I mean, you can, you know, focus on both, but you magnify it. You make it really, really big. She's looking at, we saw 30 times magnification, 40 times magnification. And so then you're looking at what they are, the stria that she's referring to are within those, like within the lands, within the grooves, these like tiny, tiny little like scrape marks, basically, usually straight, like parallel kinds of marks like that. So they're looking at that. She said no apparent subclass influence. She measured the height, the width, the depth of the lands and grooves, but she did not do that with the stria. It's because they're like tiny. Tiny. The subclass characteristics and identifying them are a large part of the training process. She's trained to know what it looks like. It's all good. It's all good, guys. She's trained, just like Melissa Oberg was trained. And Melissa Oberg has never made a mistake. She's never been wrong. Never been wrong. We know because she testified to that in freaking court. There's no standard operating procedure that says what you should look for to identify subclass characteristics. Yep, that's true. She inspected the interior of the barrel. She observed there was debris and dust inside. She said it was dust. It was dust inside. Any idea how it would get there? You're never really sure why anything would be inside a barrel. Don't know when it got there. Dust could be from leaving it in the bushes. It's dust. I mean, dust is environmental. It's like, how is that trace DNA there? We don't know. We don't know. Dust seems like a hard one to try to attribute. She ruled out subclass characteristics. She believes she did see some individual microscopic characteristics present. Again, no standard operating procedure for determining that, whether it's individual or subclass. Describes this process of test firing the gun to get the sample and also to see if the gun produces reproducible marks. So she did 6 total test fires, which is 3 sets of 2. The standard operating procedure is to do at least 2 to make sure, again, that it replicates. There's no max that you can do. It's the investigator discretion. The part she didn't mention was that when they fire 6, to decide what you're going to compare it to, which one is she going to compare to her forensic one? What do you think? What do you think? Is there like a formula, a standard? No, she just picks the best one. The best one. What does that mean? Who the hell knows? Who the hell knows? They pick the best one and they go with that. So the Mauser 98, she notes, was manufactured in Germany in 1938. This particular gun. She did not review the ATF report of the person who investigated that. Actually, I don't think she testified to the manufacturing. I think Mr. Burt just told her that. Apparently, ATF report investigated that. She didn't review it. Is it helpful to know about the manufacturer? Can be, yes. It helps to contributes to identifying individual characteristics. If you know, for example, that the barrel was finished with a grinding process, that in particular, she says, is I guess more likely to result in some individual characteristics, which does make some sense. So it's helpful to know. Again, it wouldn't matter here because it's not the original barrel. So whatever they did in Germany is going to matter for purposes of the we're at the point in the night where I'm really starting to lose my words. Like the bolt, the firing pin, the marks on the casing will be to the original manufacturer, but the barrel will not. And the bullet, the marks on the bullet are marks from the barrel. So this was all like, who cares? It doesn't matter. It doesn't matter what Germany did to the barrel in 1938 because that's not the barrel on the gun. You have no idea what the source is of the barrel on the gun. She can't recall any case where she did her test fires and they did not create reproducible marks. She says sometimes there will be disagreement among individual marks even when they are the same firearm. Same test fire produces individual marks, but there's disagreement. They're not the same ones. They're not the same ones. We got a replicability problem in firearms analysis because the whole thing is assuming consistency, right? The gun will produce these consistent identifiable marks every time that allow us to do it, but they actually know it doesn't do that. They see it. They see it happen, that it doesn't do that. It's not consistent. There's variation even, within this fairly repeatable process. I mean, there's going to be like just enough play between the bullet in the barrel, just enough variation between, the amount of powder and the efficiency of the blast and all of these things, how the fast it's coming out, the exact speed that it comes, like there's plenty of small tiny variables. But when you're talking about small tiny little marks, like that's kind of really what you're documenting. So you're seeing the problem here is, how do you tell what is normal variation within the same gun from something else that is also, by the way, capable of producing extremely similar marks? Even when bullets are fired by the same gun, it's possible to see areas of difference. She insists, however, but if she identifies, it's because there is overwhelming individual marks that are reproducible to create the sufficient agreement. She's going to the AFT standard, which we haven't got to yet. Another big problem with this discipline. We move on to AFT theory. AFT is Association of Firearm and Tool Marks Examiners. This is the firearm people. This is their group. This is their professional group. Asked if Mr. Bird, could I go in and join AFT? Oh, yeah. I mean, now, granted, most members are examiners, and there's also advisors and techs who aren't examiners, but they, typically have some kind of relationship, and anybody can get the journal. You just have to sign up and pay the fee. I have it on authority. That is not true at all. It's certainly something that I've heard before, that AFT is quite a closed group. Quite a closed group. You are welcome as long as you go and you go through their training and you pay the dues and you are remaining active and so forth. But if you're not doing that, you're not touching any of it, which is a major red flag in terms of, just this, again, like scientific validity. Like, scientists don't fear criticism. Criticism is great. It helps you improve stuff. But if you have an interest in maintaining this discipline, you're financially incentivized to promote this thing, then you're going to be more hostile to it. Because if it turns out your theory sucks, you're going to stop making money. It's really that simple. So then we go to another document. Mr. McBride wants to voir dire her on it because he says he's never seen it before. He's not sure. Oh, this is another policy. It's the AFT. It's the statement of the AFT theory from some source. I don't know where he got it. She says she hasn't seen it. Mr. McBride says she hasn't seen it. So he wants to ask her some questions based on the foundation. She's like, I can't say it's verbatim. So he objects. Foundation. Don't know that she can authenticate this. Mr. Bird asks her if it accurately states what the theory is. That was a good way around it. I gotta say. Doesn't matter if it's verbatim. Is it accurate? So she reads it and she says, well, it's different than I recall, the first statement at least, but it's overall it's accurate. So we get to see it. There's from her own file, theory of identification, range of conclusions. Part of the SOPs refers to the AFT theory of identification. So this is his proffer. Mr. McBride maintains, but language matters. Language matters if one says sufficient and one says adequate, because these are scientific principles at stake. So the specific terms really matter. Oh my God, spare me. Spare me. It's so scientific that you can't tell me why there's a meaningful difference between sufficient and adequate. What's the difference between these synonymous terms other than etymology? Is that somehow relevant to the meaning of the terms vis-a-vis this theory? Oh, this was ridiculous. I have a big, you can't see it, L LOL. LOL in my margin for that one. These are scientific principles. Oh my frickin' Lord. Bullshit. This is bullshit is what it is. Anyway. It's allowed. We get to see it. Yay. Yay. We're so thrilled with how this is going. She agrees that the interpretation of individualization of a tool mark is subjective in nature. This is not an objective thing that they're doing. She does agree with that. According to her, that means simply that the conclusions she reaches are her opinion. They're her opinion. They're not a fact. It's not a fact that you can validate and hold with a certain degree of confidence, a measurable degree of confidence. It's just like her opinion, man. The standard is based on the correspondence of individual characteristics. If there's enough, she can say there's a source ID, but she can't say it's to the exclusion of all the firearms in the universe. That's because of the AFT language policy. That's the limitation that they impose, because everywhere else in the country, besides the FBI, ATF, except for Maryland, where they decided state via Bruqua, and they said you can't do this because it's freaking pseudoscience, you can't do it. And pretty sure it was a superior court or a district court in Oregon. Last I saw, these are the only two places who looked at this when they're like, yeah, it is actually total bullshit to say you can exclude the entire universe of firearms. Nevertheless, they routinely did do it, as Melissa Oberg did. Definitely, this was Mr. Allen's firearm. No other firearm could have done this. 100% confident. I've never been wrong. Never been wrong. And how much is enough? How much individual correspondence is enough? If there's sufficient agreement. If there's sufficient agreement. This is one of the original criticisms of tool marks all the way back to the 2009 NAS report. Sufficient agreement. This is circular. Circular. How do you know if it's sufficient? Because I think so. What makes you think so? Well, because there's sufficient agreement. There's no standard. It isn't even like fingerprints, which are not great either. They're not great, but at least with fingerprints, they're like, we're looking for 12 points of similarity. 12. We have something objective in this. We don't even have that in tool marks. It's sufficient. Why? Because I think so. Getting a sense of the voodoo. So, examiners might differ in their opinions. Well, yes and no, because I'd expect any competent examiner to reach the same conclusion. Oh, get off your high horse, Missy. This is getting close to I'm not wrong territory. Any competent examiner would think the way that I do. But the threshold to find that might be different. I don't even know what that means. That seems to be saying we disagree about what's sufficient. So you can competently disagree, but not any competent person would agree. I can't with these people. I really can't. I really can't. This lady, not the worst. Really, not the worst. Ms. Carter, not the worst of these firearms analysts, but they do just tend to have this really obnoxious defensiveness. And I think it's because they do, in fact, know what they're doing is bullshit. They know it's bullshit. So they get all defensive and it comes out in these ways like this, you know? We have, more objections from Mr. McBride that this is all starting to go to the weight. Mr. Burt says, well, they waived that objection, but it's important for the court to know about it being subjective. And Mr. McBride is saying, but that's inviting you to weigh the evidence, and you're not allowed to do that in this hearing. And the court says, I'm going to overrule, but he goes back to our analogy. Remember our, let's go a mile versus 100 miles. We don't need to go 100 miles. Let's just go 1 mile instead of 100. So it took him a lot longer. The frog has not quite gotten up to temperature before he's starting to kick in the pot here relative to yesterday. So we go back to her report. And we sit with her conclusion. It couldn't be identified or excluded, the bullet jacket fragment, as having been fired from the rifle. That means it's inconclusive. There's an appendix that explains what that means. It means that there is agreement in the class, but there is insufficient quantity or quality of individual characteristics. The inconclusive means ultimately there are individual marks in this case, but they may or may not have come from the same source. So now we get to see the photos, the side-by-side photos that she makes when she's comparing her test fire to her sample, to the bullet jacket fragment that we're examining in this case. And it was amazing to see this, because you remember Melissa Oberg over there in Delphi told us you can't do this. This is improper. That's not why you take these photographs. You don't take these photographs to be able to look at them and see if she's full of shit. You take these photographs just as a memory aid to her to remember that she looked at a bullet. Help her with her testimony. She literally is saying this shit. Because when the defense is putting these, trying to show these, and they clearly don't fucking line up at all. And of course, old Judge Goal is like getting in the way and not letting us see like hardly anything and all that. Oh my Lord. I was actually... Thank you, Ms. Carner, for being sane enough and not gaslighting us that we can't look at your side-by-side micro photographs and see with our own freaking eyes, exactly like you did when you looked through the microscope, whether these lines line up with each other. That, at the end of the day, is all you're doing. You are looking at the same part of the bullet, side by side, or the jacket in this case, side by side. You're zooming in real close into the same section. And by looking at that, you have all those scrape marks, and you just see, are they the same? Do they line up? Do they go through? That's literally it. It's the eye test. So we have good eyes. We can look at it and see. And freaking Melissa Oberg. Unbelievable. Unbelievable the bullshit that came out of that woman. Just astonishing. So yeah, I mean, it's junk science, but at least we're in the sane world here of this is what the photos are for, and we can all look at them together and talk about them. Whether there are areas of disagreement or not. So we go through a lot of these photos. Here's the thing. We go through a lot of these photos. He just keeps like bringing them up over and over and over again. And he keeps asking her, areas of agreement, areas of disagreement. I'm pretty sure on all of these photos that we looked at, there was only one area of disagreement that she identified, but like multiple areas of agreement that she highlights. And we're all looking at this, with our eyes with her. I feel like this was, again, a bit of an own goal. I don't think this helped the defense at all. I think this made it look more like a match than, you're certainly can scientifically conclude. But we have eyeballs. And if you're telling us, you see if it's a match by looking at these marks line up, and we can look at it for ourselves and see, wow, there's a whole bunch of marks lining up, and there's not a whole lot here that looks inconsistent, and she's not drawing my attention to anything that's really inconsistent. These really look like the same thing. And we looked at like 6 photos of this. And we're doing this for a test result that's inconclusive, that's beneficial to the defense. I'm mind blown. I don't know why we're doing this. I understand very much the defense needs to challenge the tool mark analysis as a discipline because of the Dremel tool. The Dremel tool is where the bullshit is. Oh yeah, this bit made these engravings. Now, of course, we're not actually saying that. We're not saying it's to the exclusion. But we're playing freaking word games because we're saying I identified this as the source of the marks. So it's just like having a footnote that nobody freaking reads. That's what the jury is going to hear. This bit produced these marks, and it's bullshit. So they need to challenge that. I get that. But why the hell did she challenge the Dremel tool report instead of this one? This one is helpful. Why did you just make it look worse for your client? I don't know. I didn't understand this at all. I really didn't. We spent a long time looking at a lot of these different photos and their different magnification levels and different lighting that they use to like draw out different features and stuff like that. Wild. One, maybe two spots where they're like, possibly this is an area of disagreement, possibly, over multiple photos. She testified she does keep up with literature as well as criticisms of the apt theory. She has heard there are some recommendations on how to improve. So he asked first about the NRC. She has to correct him. NRC, National Resource Council, is not the scientific group. It's the National Academy of the Sciences, NAS. It's NAS. She corrected him. All the way back in 2009, yes, preeminent body, they acknowledged a fundamental problem with this discipline is the lack of precisely defined process. They have a theory, but not a protocol. He has this long quote about, the criticism. At this point, Mr. McBride objects. We're clearly in 702 area. It's beyond the scope. Mr. Burt says it's directly to reliability. The judge is like, yeah, but this is going a bit deep. Because you're citing 2009 and we're into 2026. So we are now exiting the orbit of PC. And Mr. Burt says, these criticisms started then, but they continue to the present day. And so judge says, all right, I will overrule the objection, but you get just this one question. And she says, she's like, I've received your point. I get it. It's been challenged. And so she's aware of the criticism. So now Mr. Burt starts to move on. Also in 2016, he wants to bring up the PCAST report. Judge interrupts him. I just said we're moving on. Go judge. Go judge. He said, oh, I'm sorry. I misunderstood. Mr. Burt, I misunderstood what you meant. And he said, I said no more on this line of questioning. And Mr. Burt said, oh, maybe, I thought you meant no more on 2029. If you meant no more about any of this, okay. Judge got some spine. He'd had enough. The frog is really kicking in the pot this time. You're not going to boil me. You're not going to boil me. You might make me a little uncomfortable. You might keep me in here a little longer than I want, but it ain't going to happen today, Mr. Burt. No boot soup for you today. In all her years of testing, she has only done one proficiency test of bullet comparisons. She did that in 2023. Pretty sure, but doesn't remember exactly. Did it involve a question involving bullets and bullets fired from another gun? I didn't fully catch the question. She's like, I don't remember what the final ground truth answers were. These are studies where they it's just like a blind practice exam. Somebody has a cartridge casing and you have a firearm and you're supposed to figure out, does it match? What's your conclusion about all this? So there's a ground truth answer that the person who created the test knows, of course, and the analyst does not. Is she aware of controversy about this particular proficiency test from 2023, that it had a very high error rate in that test? She says, my answers were satisfactory, as well as the other analysts from my lab. So lots of other people failed this one, but I didn't. The answer that she gave was inconclusive. As it turns out, the correct ground truth answer was exclusion. It was elimination. This gun could not have fired it. The reason why I think she says her answer is satisfactory is because it's not a false positive. False positives are the worst. That's where I'm saying it's your gun and actually it's not, so we're putting an innocent person in jail. A false negative is this was the gun, I was unable to identify it, so we were not able to develop this evidence against a guilty person. It's not great. But if you got other evidence, you can put them away. And it's better for the 100 guilty people to go free than the one innocent person to go to prison, as they say. So I think that's the reason why her answer was acceptable, is because it was not a false positive. It was just an inconclusive when the right answer was it's not. It was exclusion. It wasn't the same firearm. And she says in this particular comparison too, it was perfectly appropriate because there was a lack of quality and quantity of individual marks. Which kind of undercuts the point that like this is a really good discipline that everybody, you know, any competent person is going to agree with. Because if you're supposed to get to exclusion from this, but there's not enough quality and quantity, then it just indicates your standard isn't consistent. She acknowledges also, we've already talked about same gun can produce dissimilar marks, and also different guns can produce similar marks. We pause at this point because it is 23 minutes until the end of till 5 o'clock, and Mr. McBride interrupts to say he wants 20-minute cross. So we're getting close. Mr. Burt, it's my last question. So he shows the photo to the witness, asks if it shows, does this show individual agreement in these marks? This photo, look at this photo and tell me. She says, without examining it in person, I can't make that conclusion. Does this a few times. He said one more question, but now we have several more, right? Goes through all these photos, the same thing. He's showing her like photos from somebody's lab. Do these show individual agreement? She says, without seeing it in person, I can't conclude. And the problem is because when you're looking at the photo, you're looking at a really small part of the entire bullet. And in fairness to them, they are looking at the whole thing to make their conclusion of is there enough, is there not enough. They're not cherry picking like this part of this groove and basing their decision on that. She's willing to be like, you know, I see maybe, I see what looks like individual marks. I see what maybe agreement, but, you know, would not reach a conclusion, wouldn't be comfortable reaching conclusions just based on this without seeing it in person. Would it surprise you that all three were fired from different rifles? And she says, I don't know. So it doesn't really worry me one way or the other. That was what Mr. Burt wanted to do with this witness. I really failed to see the point, and I really failed to see that this was beneficial. Should have focused this on the Dremel. I don't know why you didn't focus this on the Dremel. That's the bad evidence. The inconclusive is fine for you. It's probably because all of his comparison, like this little trick he wanted to pull, you know, the little gotcha. Tell me about this one. Oh, it turns out they're different. Doesn't have that for a Dremel tool, you know, has to do it with the bullet. It's all I can really think of, but this just seemed like a major swing and a miss. I didn't get it. Mr. McBride's cross, first starting off with the last three photos. This is apparently from a study that was published in 2024 that was looking at this proficiency test that Mr. Burt brought up, that all these people failed. They're not limited to one photo in the casework to be able to make their conclusions. They have the item with them. They can turn it, they can adjust it, and so forth. She's looking for as much agreement or disagreement as she can find. She examines every landing groove, and it would be irresponsible to make a conclusion from one photo of one limited area. So that was kind of background on that. She's been at the ATF for 6 years. Before that, she did a latent print. She was a latent print analyst. She's also a crime scene tech. She has a BS in forensic science from West Virginia University. Well, now I feel a lot better about my girl. She's a mountaineer. She's a mountaineer. That's probably why she's, not the worst vis-a-vis. Like, she's actually at least willing to acknowledge some of these limitations. She's at least not up here testifying she's perfect. She's perfect, and this is the scienciest science that has ever scienced. I mean, she went to the AFT Academy. It's the year-long training. Remember, they spend most of the time trying to learn how do you tell a frickin' subclass mark from an individual one. That's the bulk of the training, and it takes a year. It's because it's bullshit. She still trains and does competency testing. Is this an area of science that's continuing to develop? Yes. Yes, it is. I don't know that I'd go that far. They've looked at improvements by, things like the 3D scanning, the more the computerized, and trying to find ways to make that more objective. We also heard in Delphi from the critic, the AFTI guy who was a little bit critical of the method. I should go back and look at that again because I forget exactly what it was, but they had this new method that's like under development that had been proposed that would make it a little bit more objective. But so far, AFTI has rejected that. They don't want to do that. They don't want to recognize it at all. Threatens the monopoly. But oh yes, it continues to develop. The fundamental problems have not, for the most part, been resolved. This whole issue with sufficient agreement, that problem goes back to 2009, the circular, the subjectivity. All of this is not new and has not changed. She still continues her membership with AFTI. AFTI takes these criticisms very seriously. Very seriously. They follow some of the PCAST recommendations. Oh, really? Oh, really? Do they now? Color me skeptical. The one thing that they've done is they have tried to, quote unquote, black box their method here for foundational validity. But what they've done is they've conflated performance testing, this quote unquote proficiency testing. How good are the analysts at doing this? And basically they just conclude if a lot of analysts can consistently do it mostly right, then the whole thing has got foundational validity. But it hasn't resolved the basic problem of you don't know what the variation is within a firearm. You don't know what the variation is between firearms. And so without that, you can't objectify any of these conclusions. You can't actually get to individualization. Lab, more about accreditation, internal audits every year. They have to do proficiency testing, variety of disciplines that have testing, serial number restoration, tool marks, bullet analysis, cartridge case analysis, etc. But the principles overlap. Going back to her report, as far as determining that the rifle was operable, she did that. She fired it, determined it was operable. She received the firearm from the physical scientist. It had a scope on it. What she does is she finds ammo of the same caliber, loads it into the gun, fires it into the water recovery tank. The reason they use that is because it retains the bullet, gives them the specimen. The water creates minimal damage to it. If you did it into something like a wall or whatever, you might leave more marks on it. You might deform it. You might make it harder to analyze. She's reviewed lots of cases with lots of damage to bullets. This Mauser 98 rifle was a bolt action. The results she got from her analysis was conclusion, is more testing possible? Not that she's capable of doing. In the field generally, There is a 3D system. This is the 3D scan stuff that is still a bit new, kind of emerging, not fully validated for court as far as I am aware, but it is available. Her lab doesn't do it though, but the FBI lab can. The list of guns that could have fired this particular class of bullet is not an all-inclusive list. It's just some, she says. Asked about the bullet jacket and what is that? She has her little bullet. She has her little model. Her little model of a bullet. It's like, you know, it's like the size of my mouse. You know, it's like a mouse-sized bullet that's got the components. And so she shows inside's the lead core. The jacket sits out here. The fragment, calling it a jacket fragment means that she doesn't have the whole jacket. Can't say why not. The 4 lead fragments are from the core, and she describes that sometimes the bullet can split when the core is pulled out of the jacket. You can't get information from the fragments, again, that would lead to that would be comparable to the firearm, because it doesn't have any marks. It doesn't come into contact with the barrel. It's inside the jacket. As far as the peeling back the petals, that lends to better comparison. It's a well-known practice. Otherwise, you wouldn't be able to see the marks. And she followed ATF protocols for all of this. We had to endure redirect by Mr. Burt. Because I guess I didn't write down the part. I was like getting bored with accreditation and yada, all the things they do to make sure it's all okay. But she apparently talked about verification. You know, they verify, and that's standard AFT. Have the one do it, the other one looks at their file, like, yeah, it looks good, checks the mark. It's probably more than that. I think they actually literally do second set of eyes with the actual bullet and stuff, but whatever. It's there to basically agree, unless like I really can't. So Mr. Burt starts, oh, you're saying your work is peer reviewed? And she says, well, it's a verification process. Are you aware we've requested the case file from your reviewer? And she's like, no, I'm not aware of that. But the thing is that the verifier doesn't keep case notes. Their notes just go in my file. It's a chart that they prepare. And Mr. Burt's like, but there's a memo. There's this memo that we got that says they don't release the materials of the reviewer. And she's like, that's not from me. That's just from one of these quality supervisors in the department. She's like, it's literally one paper. If you want, it's in the file. I'd be happy to show you what it is. He moves on. He moves on to, do you think science works best in secret? This is argumentative. It's objected to as argumentative. That's sustained. He doesn't have a good position. That's like, you should just acknowledge this is argumentative. Go ahead and rephrase it. I don't even remember how he tried to fight it, but he did. But no, this one's getting sustained. It is an argumentative question. So he rephrased it. Is it, in your opinion, is it scientifically defensible to not be able to review the verifier's work product? And she says, well, I get it, but there's no work product to show. The protocol, he's like, the protocol calls for documentation. And she says, that's in my work file. It's the verification sheet. Want to see it? Want to see it? No, we want to talk about PCAST now. And the claim that the PCAST criticisms have been addressed in subsequent studies. And yes, she means there has been an additional black box study for foundational validity. There's actually been several since then. PCAST required. One of their criticisms was you really need one more. She's like, there's been several since then. And he says, but are you aware that the criticism was finding PCAST was that it falls short of the criteria for foundational validity because it needs more than one black box study, and there was only one. Yeah, that's it. So she says in 2017, or she says they did another one. So then in 2017, are you aware there was a second report by the PCAST? And that one basically said like the existing literature that they had relied on doesn't exist. And so AFTI had responded to this and said, well, you'd missed a whole bunch of stuff. There was stuff that you didn't find, you didn't look at it. I don't know, maybe because AFTI doesn't readily share its journal. See how things can be easy to miss when you can't get access to them unless you go through your year-long class and get the certification and go work in this voodoo field. I don't know if that's why, but I can imagine it would be. There's objections to this as beyond the scope. Judges like, yeah, you did open the door to this on cross-exam. So limited questions on it's going to be okay. So PCAST responded to all this with this 2017 addendum to their report that reiterated they felt that more black box studies were necessary. And she says, and more were done. And he's like, and yeah, and you know, there's been continual criticisms of the study methodologies. Yeah, there have. I mean, this again is kind of going to the foundational thing anyway. These are not the kinds of foundational studies that would help validate uniqueness, individuality, reproducibility, etc. It's just is looking at your consistency at doing voodoo under like test circumstances. It doesn't help make it objective. It's the problem. Doesn't rely, you know, doesn't fix those fundamental problems. In fact, she attended a webinar by a group that does critiques like this. So she doesn't remember, well, how about in 2023, the Center for Statistics and something, I don't know. They apparently did a 2024 study about the methodological problems in every black box study of firearms analysis. And she's like, well, that's their opinion. And he says, well, lots of statisticians have criticized it. Yes, because statisticians will have a field day with tool marks because it's bullshit. It's bullshit. And so the whole basis to come up with any kind of statistical calculation doesn't exist. Like there's nothing to work with. There's not even like garbage to put in. Of course, statisticians are going to criticize it. And she says, then there's also research to the opposite. PCAST, we get a quote, neither experience nor professional practices can substitute for foundational validity. Do you agree with that? Yes, she agrees with that. Even though before she was like, I'm trained to tell the difference between, you know, subclass and individual. How do you know? There's no standard. Well, but I'm trained to. Little contradiction there. Little contradiction there. And asked, is an error rate greater than 5% unreliable? She's like, I don't really have an opinion on that. Got another quote, obviously a high positive. If it's got a high false positive rate, then this should not be considered reliable for court. Yes, I would agree with that. And so then are you aware the AFTI study of that one proficiency test that she did in 2022 that was very controversial? The error rate was 20.4% for item 1, 18.2% for item 2, and 18.9% for item 5. And she says proficiency tests aren't what's used to show foundational validity. And she is right in that sense, but she's kind of wrong in the sense that, like, yeah, they sort of did. It was just a scale and it was the ones they chose. She says the foundational studies are looking at black box and various study designs. It's fundamentally the same thing. How good are you at getting the right answer when you do this? Given that a right answer is known in your testing scenario, how good at you are getting to the right answer, right? You have 3 options. So if you just guessed, it's not as good as a coin flip. If you err on the side of inconclusive, then maybe, you know, going to be going to be easier to do what she did? Be like, well, but that was justifiable because the actual ground truth couldn't have been determined here, given the quality of the evidence. So you have a disconnect between the ground truth answer and the actual right answer, given the marks on it. It's just, yeah, mess. It's a mess. But the proficiency is just the examiner's results. And so, yes, you'd be concerned about this high error rate, but you would examine that to see where the error is coming from. Now we get some recross from Mr. McBride. This science is routinely accepted across the country. It's routinely admitted in court studies. Many studies approve of it. That's the end. I was waiting for Mr. Burt to get up and say the words Abrukwa, State versus Abrukwa. Have you heard of that? That's the Maryland case that did not, stopped routinely, said, we got to draw the line. This is bullshit. You don't get to make these excessive claims. But probably didn't, because then they'd get in a rabbit hole about the DOJ language is, at least in theory, avoiding the problems that the Abrukwa court identified. It's not that they won't let tool mark analysis in, it's that they won't let the overclaimed conclusions to be made. That it's this firearm to the exclusion of all others. In Maryland, after that case, all they can do is say it's consistent. It's consistent with the gun. And that's kind of fine. Like, yeah, that is the limit of what you can know. That is the limit of what you can know. And is it a helpful thing to know? Maybe incrementally. There's still concern about, you don't necessarily know what that means. So what if it's consistent? If different guns can be consistent, then how is it helpful to know that this is consistent? Oh, finally we were done. We were done with this tool mark stuff. Oh, Lord. It was painful. It was a long day, but we're not done for the day. I still got multiple pages left, guys. And that's because when we came back, we had a brief recess, like court's done, witness goes, but we come back into session. So Ms. Nestor advises the court, we have one more witness. It'll be fairly short. We expect to be done by lunch tomorrow. The state is not anticipating any rebuttal. Wants to know, are we going to argue bind over? We're prepared to do that at the close of evidence. They're estimating a routine, nowhere close to needing the whole day tomorrow, even if they did argue. If, you know, both people needed 2 hours apiece for a bind over, they'd have a problem, says Mr. Grunander. Ms. Visser, then for the defense, says, well, we request to submit briefing because there are some legal issues here. We'd like to brief that in writing. We're open to page, time limits, etc. But I've done it like this in some courts before, and I'm expecting the state to object, but they want to file written briefs on probable cause. The judge wants to know, are you waiving oral argument? She says, well, in the multiple cases where I've done this, I've asked for an opportunity to brief and then argue. But she doesn't think the argument would take a half a day, especially if the briefing is submitted before, maybe 2 hours total. So Mr. Grunander says he'd certainly prefer to argue tomorrow because you have the evidence. But if you decide the briefing is necessary, we could probably have an expedited transcript by Monday. So we would prepare the motion because we are the party with the burden of proof on probable cause. Ultimately, we're getting to about 6 weeks out to argue the bind over. We'd need about 2 to 3 hours to argue. If the court wants briefing, then we would argue after that. Ms. Visser says we would be okay with simultaneous briefing, meaning instead of the motion, opposition, reply kind of format, we just both file the same brief at the same time. She doesn't want the state to have a chance to respond to what they say. She doesn't object to the 6 weeks. And the judge is saying, well, you know, what you're asking for, of course, now is going squarely into the victim's rights for a speedy, disposition. It's great that your client will waive a speedy trial, but we have this other thing to consider. The state says they do not want simultaneous briefing. They want to be able to respond to the defense's position. Mr. Neiman gets a chance to talk. We want swift justice for Charlie. The sooner the better, so that we can get it set for trial. Foregone conclusion for him that PC is going to be established. Court should decide, if the briefing is necessary. We just want it speedy. He made some comment about, like, to me, it's just my opinion though, but to me, seems like we're pretty overwhelming proof here, but little throat clearing with that about how not really much of an issue PC is. So the judge grants the request for briefing of probable cause. He's first saying that the defense is the moving party. I think he means because the defense asked for the motion, but the state jumps in right away. We have the burden, so we should initiate the brief, and then we'd have the right to reply. So very clear, that's what they want. They want to have the last word. So we go through this kind of calendar calculation to figure out, you get the transcript on Monday, you have Tuesday to start, 2 weeks from there. State's brief's going to be due July 28th. Defense is 2 weeks after that, August the 11th. The reply would be due then a week after that, August 18th. Argument, his first availability is September 1st in the morning at 10 o'clock. Ms. Nestor, can we do it the next week? I'm in trial. The judge is like, it's actually very fortunate that I have this opening at all. So Ms. Nestor is like, all right, we'll take it. So we are set for an argument, in-person hearing, September the 1st, 9 a.m., estimated about 2 hours after the briefing is filed. That's why we're now talking about another 2 months and still only just arguing. Probably still don't have a decision on probable cause yet. Although we do have more likelihood, I think, if they're filing written briefs, that the judge would decide from the bench because he would have been able to prepare already. But then that, again, kind of means he's not really hearing the argument. The argument's not really meaningful. So, don't know. We'll see. And that would take us, to almost a year from the event, and we don't even have PC or a plea yet. Welcome to death penalty litigation. Then we turn to page limits. Page limits, yes. Good idea. Good idea to impose page limits. One of my favorite war stories from back in the day when I was up against one of these old boy litigators. Small town, and so, the guy has been there forever. I'm still a little bit, relatively new. I mean, I'm not a green lawyer at this point, or baby lawyer or anything like that at this point, but I'm, haven't been there anywhere near as long as this guy has. Anyway, we have this hard fought, long, drawn out, super contested partition case. It's a partition of land. This family, such a long story, owns all of this land with fractional interests, and it needs to be divided. They can't agree upon how. This has been going on, this dispute, for like at least a decade. So we ended up taking it to trial, have this long fought trial, finally get to the end. It's a trial to the bench. And we're talking about submitting closing arguments in writing, and the judge is asking, about the logistics, and then it occurs to him, perhaps we should have a page limit, and the state says, that's a very good idea. Not the state, but my adversary, this old boy. So it's a very good idea, Your Honor, because otherwise you might find yourself reading a novel. And I said, that's fine with me, Your Honor, because I only write nonfiction. And I was so proud of that dunk. So proud of it. Here I am still telling it years later. It's like probably my favorite moment in court ever. It was fun. Really enjoyed that dunk. Even his own clients were laughing at him. Oh, I got him so good. Anyway, page limits, yes, a good idea. So state says 30. Defense, I'll counter with 40. Court's like, we'll do 35. We'll do 35. I don't even care. It's an odd number. That means you normally get half for the reply. It's going to be weird. 17 round down. No, 18. All right. They'll round up and they get 18 for the reply. So 88 pages, more of briefing on probable cause, and then a hearing on September the 1st. He reiterated that he has reserved the ruling on the Kirk family request vis-a-vis the altered portion. We kind of go back and forth about like how much of it. Judge thinks it's 1 minute. Neiman says we want the whole video displayed. I think it was about 8 minutes. And so he says tomorrow at the conclusion of the defense case, we'll address it. And again, it's just the victim. Representative wants to see what the court considers before the bind-over decision. And since this is before that, it would seem to comport with that request. And so he says he will grant it. It will be played in open court, but not televised. It's only going to be in the courtroom. So in the courtroom, they are going to get to see that enhanced video, we at home or not. Again, we've seen the part of the guy going off the roof. That's part of the FBI release. But I really wanted to see the enhancement of him going to the corner and like what's in the corner. Hoping to see that, but there will be people present. So hopefully we'll be able to get some details from that. Well, it's gotten late already. We got some comments to get through, guys. Hope you had a little fun comparing this lady to Melissa Oberg, going through the Lance stuff. It was a lot today. A lot to get through. Catchy 333. Maybe I missed it, but how is Lance's depot interview not violating Tyler Robinson's Sixth Amendment right? Prelim doesn't require that. Exactly. Limited confrontation rights at the preliminary hearing, according to Utah, according to a variety of other case law. So nope. Limited confrontation rights at the prelim. Absolutely is going to have to be present at trial. No question about that. Ginger Puff gifted 5 memberships. Girl, thank you so much. That's awesome. Thank you on behalf of everyone who got one. Animals over humans, here's to redemption. I will drink to that. Thank you, sir. I'm glad that you share that. Ginger Puff 764. Andrea, why no defense cross of Agent Davis? Here's the possible reasons. Because they have nothing to work with. One possible. There's nothing to cross him on. There's nothing to gain from crossing him. Number 2, they don't want to show their cards with whatever they're going to cross him on. Those are pretty much the main reasons why you wouldn't. You have nothing to gain, or you just have nothing to gain by doing it right now. Hard for me to see why they wouldn't cross him with anything they have to cross him with, given what they have been crossing the other witnesses with that seems pretty inconsequential. Particularly if they had something really, really good. It's like the one thing you don't cross on. You cross on everybody who you have this minor stuff on, but then the one guy that you can nail for perpetrating a fraud on the court, you don't ask him anything at all. No, this is not plausible to me whatsoever. So I think at the end of the day, there wasn't really any advantage they saw to get from it. I will say, I think one other thing that may have factored in is because we heard from Michael Burt, we knew that this witness, they had the scheduling issue, and that's because I've already lost her name. I just don't care. Carner, the ATF lady. She had to leave today. She was here today. They needed to get her in and get done. So it's possible that they just like accelerated, but I don't think that happened because they could have just asked to take her out of order. They could have just explained to the court and to the state, we got these scheduling issues. We want to do some cross of him, but our time is really tight. We want to make sure we get to the AFT lady. Can we do her first and then come back to our cross? Because this guy's here in Utah, he can come back. And I can't imagine they wouldn't have accommodated that. So, possible, but I'm doubtful. I'm skeptical that would factor in this particular situation. So I think it's mainly just there wasn't really anything to cross him on. Nothing that was going to be material in any kind of important way. Harbinger of imminent death. What limits do they have on searches during exigent circumstances like these? No shooter in here, but cool meth lab, bro. We'll come back for that. Exigent circumstances is one of the exceptions to the warrant requirement. And it gets used quite frequently. And that's exactly what happens, because once you found the meth lab, you're in the place you're lawfully allowed to be because you didn't need a warrant because the circumstances are exigent. But here's this meth lab in plain view. It's in plain view. You're not required to close your eyes to evidence of a crime where you are allowed to be. Yeah, you get to prosecute those people for that meth lab. As long as you are in the place, lawfully in the place, anything you see, it's illegal. You can use that. It's in plain view. And so the exigent circumstances allow them to not have to get a warrant to go looking for the active shooter. Base player 2011 IFY. You can tell Slovak isn't used to not getting his way. He did more damage to the defense with one outburst than any of the evidence. Do you mean Slovak or do you mean Bert? Which one do you mean? Because I thought Bert did worse today. What did Slovak? I felt Slovak was on very good behavior today. I thought he just had a little whiny about, we didn't ask for that one transparency thing. That was the court's whole idea. But otherwise, he was mellow. It was Bert. It was Bert who had that little blow up. It really surprised me. Don't think that helped. Can't imagine anybody. Most of the people watching were real appreciative of that. Brian's Ramblings 0602. Nice job. Well, thank you, sir. Appreciate the compliment. Sarah 58-1. At this point, what do you, if you were the judge, believe your probable cause finding to be to bond it over to trial would be? Oh, no question. There's probable cause. No question. There's probable cause. This is it's a very low standard. A lot of this stuff standing alone. I mean, I mentioned before, as long as you have evidence of a crime, if you had a confession like this, like the text messages alone that has the details of like the rifle that was wrapped in the towel that's corroborated, and he looks like the guy on the video and stuff, that in and of itself would be alone. That would be enough. And then they threw in the Dremel match, and they threw in the DNA and all that stuff. So yeah, they're ample. PC is low. It's just to get it to the jury. It's not anywhere near proof beyond a reasonable doubt. It's not enough to convict. It's just enough to warrant enough suspicion that this guy should have to go through the trial process. Easy, very easy. I don't think there's any doubt that that's happening. Now, there may be on some of the details of some of the lesser things, and there might be on, some more wiggle room on the aggravator, the thing that is elevating this to a death penalty case altogether, because the aggravator has always been kind of slim. We didn't see a lot of evidence at this hearing. There is a lot of evidence we didn't see that might relate to it. But we'll talk about that. That's going to be tomorrow. We'll sit and we'll go through the information, and we'll go through all of this piece by piece, and we'll talk it through. But for all practical purposes, other than the aggravator, which is pretty important characteristic of the case, the other charges, the enhancements, so forth, these are throwaway. It doesn't matter. Nobody really cares if they don't get to charge him with obstructing. Like, it doesn't, it's so nominal compared to the murder charge. User XR numbers. I bet AI will master this science in 5 years, maybe less. I wonder if they'll do it better than the examiners will. That's where this 3D scan, stuff is going, is the 3D scan combined with the machine learning. That's where it's going. So we'll see. we'll see if our robot overlords will be perfect and never wrong. I mean, they'd have to be to improve on Melissa Oberg. So why would we even want to go there if they weren't perfect and never wrong? Able to reach conclusions that, scientists and the Department of Justice and the FT and courts in Maryland and Oregon have said scientists can't legitimately reach, but she can. So it's going to be tough for AI to top that. You get what I'm laying down? You get what I'm laying down? Incentives. How is it better for the state to have that AI than to have Melissa Oberg, who will come in and say whatever will get you that conviction? That's some food for thought for you. All right, guys. It's not super late, but it is a little late. And we do have the early morning start tomorrow. It's not a full day. We can nap in the afternoon, but nevertheless, time to step away, get our Z's before the morning comes. So last day tomorrow. One more defense expert, another ATF. I wonder if it's the Dremel person. I kind of assumed it was going to be, because if I remembered right, it was DNA from the ATF, tool mark from the ATF, and then DNA from the FBI. So I kind of thought it was going to be ATF DNA, but I do wonder, because I'm having a hard time seeing the point of this particular tool mark evidence. Like, I don't know why you didn't just stick to the Dremel. That's the part that hurt you, and you didn't even talk about it. I don't get it at all. But we'll see. We are well over the hump, guys. So one more morning. We'll see where we're at. We'll have a fun recap tomorrow. We'll look at it all, put it all together, look at the information, see where we sit, see what you guys think about it. What do you guys think about PC? Maybe we'll do some polls and stuff. It'll be fun. So yeah, guys, good one. It'll be I think I'm going to keep it at the same time. I know it'll be a shorter day, and so theoretically we could bump it up earlier, and it is Friday night, but just for consistency's sake, it's going to be easier for me to kind of stick in the 7:30 mindset. So, if you guys are nerdy enough to spend your Friday night on stuff like that, I would certainly appreciate your company. It would be great. I'm too old to really do much else anyway at this point, so I'm just going to be hanging out. Might as well come hang with me. So I'll get that, get that all set up and posted for tomorrow. So those links are available. And with that, guys, thank you, everybody. Thank you, mods. Forensic Furors in the house, doing the late nights. Jeff, of course, doing the late nights. It's just 1 week, guys. We can suffer a couple hours of sleep loss here and there. It's not the end of the world. It's all good. Thank you, guys. Really appreciate it. Enjoyed this one. Big day. So much to talk about. Appreciate you guys being here, and we will see you tomorrow.